Yes.
Under compelling circumstances, my lord, I am mentioning, my lord, with your lordship's leave, my lord, may I be permitted to mention before Honorable Justice Mitru?
Oh, no. No such leave can be.
My lord, one matter, my lord, sitting singly, my lord was pleased to direct the authority to do the hearing and do the demarcation, and my lord was pleased to fix the matter on 2nd of July. Sitting singly. My lord, in that matter, my lord, my urgency is the authority has been hearing me on 3 occasions now into my property, the Rayati property. My lord, the local councillor is, my lord, putting up everything.
That must
Construction.
that must have been a contempt, sir.
Yes.
So how can a contempt court go into all of that?
My lord, keeping the matter pending before the authority, my lord, this is happening.
এই মান্থার সাথে বেঞ্চ করে আছে না শুক্রবার
Singly
My
from
lord.
3 p.m.
My lord.
It will appear in the list on Friday.
My lord. আমি কি আপনাদের দিয়ে দেবো? My lord. আমি দিয়ে দিচ্ছি এক করে।
My lord, I am for the petitioner, my lord. My lord, with the kind leave of your lordships, my lord, this petitioner, my lord, this Sean, my lord, saw his father after 1 year, my lord, more than a year. My lord, this is the
But the
my lord
brother and the
peacefully
sister-
happened, my lord.
Brother and sister,
My lord, that matters, my lord. 93 years old father, and the petitioner is 62 years, my lord. He was not allowed to see his father, my lord, and even no trace out. Then your lordships, with the intervention of your lordships, my lord, he went, saw his father, my lord, very deplorable condition. In a deplorable condition, he is confined, and tears are coming, my lord. Very my lord, however, my lord, he saw his father, my lord, and my lord.
so we will no further order is
No
required.
further order is here, but if the my lord the leave is expressed, my lord, for in future, because of the petitioner is not, my lord, has been, my lord, asked.
If you go and create any property allegation then
Nothing, my lord, only to see my father. That observation, my lord, only to see my father. No father claim or
that he has not denied, your brother has not denied.
But we have also kept our personnel in plain clothes. We have also kept our personnel in plain clothes at the ground floor of the building, so as to see whether any untoward incident happens or not. My lord, nothing happened. They have peacefully seen the father, and my lord, there was a cordial discussion between the father and the son, where the opposite party also was not present in that room. Thereafter, he silently left.
both are crying, my lord.
Pursuant to the earlier order,
দেখতে দেবেন, ওরা আপনাকে জানাবে, দেখতে
হ্যাঁ,
দেবেন বাবা।
দেখুন না, দেখুন না। এটা তো modification আছে।
My lord, I am for the petition. I am for the petition, my lord. Here, my lord, an
In
employee,
habeas corpus also, Mr. Roy.
my lord, an employee was, my lord, not
May I
found
hand-
from his workplace. An employee of CLW in the rank of, my lord, senior technician. He stepped in to the, my lord, the workplace.
Any development?
My lord, in this matter, I am appearing for state, my lord. My lord, I have already handed up the reports, my lord. My lord, every possible step has been taken from publishing in the by sending a letters to OC missing person, my lord. My lord, CM
Yeah,
is
just. ফাইলের মধ্যে থেকে একটা নিচে কোনটা চারের ফাইল দুটি কেস রেকর্ডগুলো থেকে আসেনি আর ওই রিপোর্টটা আছে এটাই বলছে
my lord, my lord, at page number 3, my lord, in paragraph number L, your lordships will find that on June 18, 2020, at the request of the concerned person, privilege pass was issued in his name.
Give a copy of this report to Mr. Roy. Give a copy of this.
In the
report to
earlier
Mr.
report, the same thing has been, my lord, they have stated, but they have stated it was not issued.
What order do you want from us?
It
Mr.
was not issued.
What?
The
What
pass was, as they are trying to mislead the court, my lord, that a pass was, my lord, sought for, pass was issued, but it was not received by him. So the sorry state of affairs is this, my lord, that a person was missing from the workplace. And investigation is this.
2020.
My lord, 20, we lodged complaint on the next day, my lord. On the next day, we lodged complaint. On the second day, we lodged complaint with other PS, my lord.
What order do you want from us? We are in
My
a
lord, we
habeas.
want that his body should be produced, my lord.
If the person is not cannot be traced out,
My lord, my lord, by an order
how
dated,
can we direct
my
the
lord,
body
by,
which is
by an
missing?
order dated, my lord, 12th February, my lord, the case was handed over to CID to a competent officer. A sub-inspector was deputed for investigation of the case. DIG was directed to ensure proper compliance. And court observed the life of a person is involved.
Where is the order?
My lord,
Which order?
dated 12th February, my lord, 12th February
12th February of
of 2025. At the material time, the police authorities have not done anything. And it is the CLW who will answer where he has gone. Whether he was murdered, whether he was rather committed suicide, whatever that may be. Why they are making hide and seek? My lord, paragraph 2.
who is appearing for CLW?
We have recorded.
Now it is when you are leaving the workplace, it is automatically recorded in your
It was during the COVID period. In our affidavit and point number 3, it has been mentioned, Lordship.
you have filed your affidavit.
Yeah, Lordship, yes.
Oh,
Very casual affidavit, my lord. There was CCTV surveillance. My lord, kindly see the order, my lord, for a moment. Your lordship got it. It appears that the local police is at its wit's end and is not in a position to find out the missing person or gather any information about the whereabouts. The life of a person is involved. Let investigation of the case be made over by the present.
Mr. Roy, we are asking you what order do you want from us?
My lord, we want the body of the.
We don't want you tell us what order you want from us.
My lord,
You are in a
if
habeas
they are if the CLW is, my lord, held responsible, then they have to.
that the criminal proceeding is pending. Let them investigate and file a final report. If it is a final report, go
My
and
lord,
file
here
petition.
where the high
On the basis
here
of
where the High Court was monitoring the matter.
no, High
They
Court
are,
is
my
not
lord,
monitoring.
my lord,
High
they
Court
are.
has only said transfer it to CID. Now CID has filed a report which prima facie
My lord,
gives
that was
certain-
not even my lord, investigated by a competent officer and was not supervised the DIG of the police. My lord, what they have done, they have gone
You have
to.
not even seen the report and you are making.
My lord, this is the copy of the
Forget
report.
about other report. Have
My
you
lord,
seen
that
this?
report, that
You are
report.
not agreeable to go through the report.
No, my lord, that
You
report.
want the order just now that produce a dead person. This is not advocacy, sir. It is not an adversarial litigation. We are all sorry for the loss which has been suffered by
My
the
lord,
client.
my lord.
So you are going into an adversarial tussle.
My lord, that
Why
is.
they should not give? Why CLW will not give? Please, Mr. Roy.
Copy it. For the sake of investigation, my lord, the mobile phone numbers of all the relatives, mother, son, all daughters, near relatives.
Allow us to go through.
My lord, my lord.
Where is your previous report?
My lord,
The previous report which you
the
filed?
report dated 10th March 2025
Acha,
as
10th of March.
March 2025, my lord, will indicate.
Last report,
That
my lord,
the-
22nd April 2025.
Kindly allow me. Will indicate that the CDR Aadhaar card 10th of
We are
March.
asking that after the 17th, after the 12th of February order, did you file any report?
My lord, 10th March 2025,
But that is not in our file, it appears. 10th March?
2025, my lord.
Daw to daw.
My lord, may
করবে না? Only after our order, CMO each held this chiefs. The 26th April order. 10th March. 10th March থেকে তারপর 26th April। হ্যাঁ, সেটা তো কি বলেছে? তা তো ওই একই কথা বলবে, একে জানিয়েছি, তাকে জানিয়েছি। দাদা, এর কি একে জানিয়ে কোথায় বলেছে? এর আগে চিফ মেডিকেল অফিসার, when did you approach the chief medical officer of the districts? Okay.
My lord, since the matter has been transferred to us,
এইটাই রিপোর্ট
all along,
ক্লজ কেটা হচ্ছে সেম অ্যাজ ক্লজ
Lord, report dated 22nd April is a reflection of the earlier report except O and P. Paragraph O and P. All our paragraphs are same.
সেম ওয়ার্ডস থেকে অভিষেক দিলো বললাম what has been received.
This OP also included in that report.
হুম। ডেপুটি ইন্সপেক্টর জেনারেল ছিলেন দেড়শো কোটি জনসংখ্যা Pen drive.
Lord, in this matter,
For the state.
Lord, your lordship's earlier direction was to exchange the affidavits because an application for addition of party was filed by the wife of the petitioner. And my lord, habeas corpus, habeas corpus petition, my lord, is by husband against the wife. First point, my lord, is whether habeas corpus petition is maintainable.
Who is for the wife? Who is appearing for the wife?
My lord,
Last occasion, someone appear on behalf of the
wife,
wife, my lord.
Lord, he
So did
filed
we-
an application.
Did we allow this addition of party application?
Yes,
We allowed?
yes.
Oh,
Lord, we agreed. I have agreed, my lord. Yes, let it be allowed here and now.
we are saved. When Mr. say you have agreed, we have.
Lord, I know, my lord, that she will be added.
But
Why
who
should
is
I?
who is the
Why
advocate?
should I argue, my lord, unnecessarily?
এ তো
Lord.
বুঝলাম।
And the respondent number 5, my lord, was the wife and who was added as a party by your lordship.
চিরন্তন সরকার appeared.
Yes.
He appeared on the earlier occasion. She appeared.
Sarkar and Sultan A. Mondal.
And my lord, matter was fixed by your lordship on today, my lord, because I was in difficulty on the last occasion. Mr. Pine has taken time.
Affidavits you have filed. You have filed any affidavit?
No.
You have filed any affidavit?
No,
He
affidavit
did not file
Did
any
the
report
wife
also.
file any affidavit?
Yes,
Yes,
Lord,
my lord.
No, no.
Affidavit in
Your
but affidavit
reply
in
is not.
opposition has been filed by wife.
Oh, acha, your reply is also
I
there.
reply have also filed.
also filed.
Now, Lord, state
Records reveal
state
that
authority did not.
the records reveal that the petitioner and the respondent number 5 have exchanged their
Before my learning trade starts, my lord, I would beseech upon your lordship, my lord, quickly.
Just one more. Yes.
See the report which we have filed on the other date, my lord. And
We
the
have no
annex-
copy.
And the annexures there to me.
Your lordship, we don't have a copy of that.
We have
He recorded Mr. Sinha Roy. He recorded. Huh? No, Sinha Roy appeared.
my learned friend on that day, but it took time to take instruction. My lord will kindly see the
Mr.
report and the annex.
What information you have got? Your mother is there.
Your lordship, may I just indicate one thing?
He is residing here.
We have,
Document is given.
we have filed another can on this. With respect to this, we have filed a can 1 of this. Yes, sir, we are giving him copy now. When was it?
Why CCTV footage required?
Your lordship, may I just indicate one?
Who are you?
I'm the daughter.
Daughter.
I'm the daughter. Now, I'll tell you exactly what has happened.
And the
We have
private
gone there. We have
respondent?
gone to the place which was indicated, the address which was indicated, where my mother is residing. We have gone there. She's not residing there.
She's not there.
She's not there. We have also filed a police complaint with regard to that in the Nagarbajar police station also. Your lordship, may I just indicate what has happened here and what transpires?
When did you go?
It was 29th of June. June, right? June. 28th, 29th of June.
So at that place, she's who is your private respondent? You are the daughter.
I'm the daughter. May I just indicate what has happened, your lordship? Then I'll come to, and this will borne out the facts. The entire mischief which we are complaining about is our promoters who wanted the building, and my mother is a part owner of a joint family property. She earlier acceded to the fact that it will be promoted. Thereafter, what happened is she withdrew her consent, and thereafter she goes missing. When we file, then we file this writ petition, habeas corpus. Police comes in and they have filed this report. We don't have the annexures, your lordship. I don't know what exactly. We don't have the annexures to this. But now the thing is, the police immediately identifies her, which is the very strange part. Police doesn't bring her here. Police identifies immediately her as the woman. Now, who is this person? Any woman can come in and say that I am that particular person. That is why the CCTV.
It was told to you that she appeared. There was a statement.
That is exactly why, your lordship. Any woman can come in tomorrow.
That is your apprehension.
No, your lordship, that is a valid apprehension when I'm making a habeas corpus, when there are two addresses, a woman who has otherwise no money, no sustenance, disappears and suddenly comes up to a police station.
And the other complaints too.
Yes.
Attached with the
Your lordship, this is very interesting. For years, she goes on making complaints against the promoter. And I have been helping. I have
not been given any share from that. That is your.
There is no question of a share, your lordship.
Oh, I see.
It's not a question of a share. My mother is missing. My mother is not there. I have filed a habeas corpus petition. Police suddenly comes and produces due documents saying a woman came herself. We don't know whether she came herself or with other people. There is my brother who is also missing.
We are not required to go into all these things.
Your lordship.
We want to ensure whether the woman is residing at any place or not.
Your lordship.
Whether she will continue to remain or she will come
absolutely,
back.
Absolutely, your lordship. The police can take a
assertion. Where is your evidence? You have filed any statement?
Yes,
I on such and such date I went.
Yes, your lordship, in can 1.
Yes. Where, which paragraph you have said?
Paragraph 8. Page 8, sorry. Page 8, paragraph 3.
এই ছেলেটা না মানে এই যে ফোনটা
Met position.
My lord, my lord, I, my
Yes.
lord, item number 5, my lord, Mrs. Chandri Alam is appearing in this matter for contemner responding. My lord, her husband has been hospitalized and serious condition. So, my lord, in this situation, I am praying 2 weeks' times, my lord.
I should.
What, any affidavit was called for?
Yes,
My lord,
the question is there. I have already
she
served
will-
on the earlier date. May I just file this exception? And if the lordship pleases, my lord, it could be
my
adjourned.
lord, we will file the affidavit in opposition of the exception petition, my lord.
Not required, miss. You filed an report.
No.
They filed a compliance report against which I took
Compliance
the
report
exception.
I have, and then I will file the affidavit of the exception petition, my lord.
Is it required?
My lord, some, I sent the instruction, my lord.
My lord,
Some instruction is necessary.
Lord, may I just pray one thing, my lord? If they want to use an affidavit against my exception, that would be, my lord, beneficial for everybody else. So if that could be, my lord, allowed, my lord, that would be good for us as well. Because I have specifically stated, my lord, how they did not comply with this. If they cannot substantiate by anything.
Yes.
Mr. Royal Learned Advocate appearing for the petitioners files the everybody. Problem to solve.
This is my opinion.
Well, Mr. Bandyopadhyay concluded his submissions on the last occasion.
And Mr. Mojumdar was starting.
Yes.
So far as my clients are concerned, my lord, they have not implemented me as a party respondent.
Not necessary.
But my lord,
They are
in
not
context,
necessary parties.
my lord, the concept of necessity, my lord, will come later on.
Well, let me make my
No,
submissions.
my lord,
Well,
because the story that he tells your lordship, my lord, there is an essential element of banality, my lord, because my lord is absolutely, my lord, all shadows and no substance. Because my lord,
Mr.
we
Basu,
were,
you have used any
my lord,
application?
my lord, I, my lord, sought to intervene, my lord, in the proceeding. Because my lord, in the contempt, my lord, we are implicated in the as contemptors. We were not made party. Allegations were made against us because we are the persons, my lord, whom
well, they are not in appeal before your
my
lordship.
lord, the concept of Order 1, Rule 110(2), my lord.
At what stage?
No, it is a question of not a stage. At
The
stage
state's appeal. My Mr. Basu must understand it is
Milord,
state's appeal.
Milord, I am always ready, Milord, to learn from Mr. Mujumdar. He is a learned senior friend. Because the question is, Milord, 107 of the Code of Civil
No,
Procedure.
then you should learn first, Mr. Basu.
No, Milord,
Then
from
you
Mr.
should cover.
Milord, no, Milord.
No, you
Question
said
is, Milord, 107 of the Code of Civil Procedure. If it is a continuation of the proceeding, the appellate court exercises its power, Milord, like the original proceeding. And the writ petition is the original proceeding. What are the documents, Milord, placed?
Mr. Basu, have you filed any application?
Milord, I sought for intervention because the court should not
You
look
could have
into the
filed by
petition.
this time.
Then,
It was
Milord,
heard earlier on 25th of June.
Milord, I tell your lordship, Milord,
One line
they are
application.
seeking order against us without making us party. They implicated me in the contempt jurisdiction, in the contempt.
So you are
The
against the appellant. You are against the state.
No, my lord, he is against
Milord,
the respondent. But in the
Appellant
state's
is the
appeal,
It is a state's
in the
appeal.
state's appeal,
Milord, in the state's appeal, in the writ petition, Milord, Milord, did not implicate me as a party respondent. They filed a contempt.
it is for them
alleging,
to
Milord,
prefer appeal
that we
against
are
that order. They did not prefer any appeal.
Mr. Basu, we shall hear you.
Yes.
There is
Yes.
no application on your behalf.
No, but
Anyway, when you
right,
are
right
The
of
whole
audience,
idea is to
Milord,
stall the proceedings. We
No,
understand that.
why you were sleeping from 25th?
Yes.
Today we are on, today we are on 2nd July.
Milord, we sought to, my lord, impress.
Just wait.
There cannot be any order. Sorry, sir. I apologize.
My brother corrects me that on the last occasion you appeared virtually and it fell from us that please come with an application.
Milord,
You might not have heard my brother.
Milord, there was a network issue, Milord. That is why your lordships were.
Acha, let us hear the
May I just make my
My lord, will it be your lordship's pleasure, my lord, that I give a short recap of what I submitted, or my lord?
Yes, Mr. Just for 5 minutes. Yes.
My lord, the direction upon us, the principal secretary, was to consider a future representation which is to be made by the writ petitioner on a future date, and we will have to consider that representation and place the decision before the honorable court on the returnable date. My lord, the crux of the petitioner's grievance is that they are being restricted by the private respondent number 5 in the writ petition from pursuing their profession, which is making films. And the nature of grievance is also that technicians are not agreeing to work with the writ petitioners at the behest of the respondent number 5, because the respondent number 5, which is a private trade union, respondent number 5 is a federation of trade union, I stand corrected, my lord. They are restricting the technicians from working with the writ petitioners. And, my lord, I had placed, my lord, paragraph 9 of the writ petition and showed the sub-paragraphs that what are the nature of grievances that the petitioner wishes to canvass before the principal secretary.
So those technicians are not members of the federation?
My lord, the technicians are members of different
Different
trade
associations.
unions, like the trade union for directors, then for cameramen, then for hairdressers, then for beauticians, like this. They all come together and make a federation, which is the respondent number 5 in the writ petition, here represented by Mr. Shoma Majumdar. He was appearing on the last day, my lord. So this is the grievances against this federation.
Then
That
who is Mr. Majumdar?
he is the individual director who says that I have lot of work, but since the technicians are not working with me, I am not being able to pursue my work. And that is a writ petitioner. And that is infringing my right under Article 19(1)(g). And for this infringement, state must intervene and iron out the creases. Because on an earlier occasion, that is July 2024, the Honorable Chief Minister had intervened when the film industry, there was an impasse in the film industry. Now, we have come up in appeal saying that, first of all, their entire grievance is against respondent number 5, and there is no grievance against the state, which can be redressed by the principal secretary. Though, my lord, the order may seem extremely innocuous, that only a consideration has been directed. But the question is, what kind of consideration has been directed of me? And I invited your lordships to go into the merit, at least prima facie, to see what I was being invited to address. And for that, my lord, I had placed the paragraph 9 of the writ petition. Just, my lord, for your lordship's kind recollection, I am not placing it in its entirety. My lord, it contains, my lord, if your lordship kindly takes page 41 of the stay application, which is paragraph 9 of the writ petition. (9)(a), that members of DAEI, DAEI is the trade union of the writ petitioners. Directors Association of Eastern India. Members of DAEI had to compulsorily hire catwalk even when one was filming outdoors or on locations when the same was required shooting inside a studio. DAEI had to compulsorily hire a minimum one trolley.
Yes, those
setting.
are the grievances.
Grievances which
Respondent number 5.
again respondent number 5, which they wanted the principal secretary to address now, because subsequently they have given a representation.
Now you showed us page 132.
Right. That is the instructions that we had filed before the Honorable Single Judge, which compelled the Honorable Single Judge to pass this order, my lord, which in my humble submission ought not to be, because we had made our stance very clear. My lord, increasing the scope of the writ petition by directing a future representation to be filed, my lord, this has a snowballing effect, my lord, upon the state. Because, my lord, we apprehend that once we place the decision,
these persons who is having no locus will now suddenly have a locus, then to challenge that order, say that the order is not justiciable, the order is not equitable, so on and so forth. We have not been appropriately heard, and your lordship knows the grounds which are taken, my lord. But my lord, this situation is not at all, my lord, needed, because my lord, the grievance is between two private players here.
State can solve the problem also.
But state
you're
stance is very
anticipating.
clear. My lord, state stance is absolutely, my lord, clear as far as page 132 is concerned, that this is a dispute between two trade unions. I have nothing to do in this. And even the nature of grievances, my lord, the state cannot, my lord, even if your lordship looks at it from that perspective, that my lord, if I may put my submission in a question form, that how can the principal secretary decide how many hairdressers will be required for which actor and which actress? It cannot be. My lord, they are guided by their own, my lord, memorandum of understanding or something between the trade unions. It has to be guided by this.
Why did you give the impression that you were going to make a review committee which would solve this impasse?
Well, in July 2024, there was an impasse. The hierarchy and the bureaucratic hierarchy thought it fit to intervene to sort out that impasse. Now, there is no denying that in July 2024, there was a verbal intervention. What I'm submitting today is that, my lord, just because there was an intervention in July 2024, well, that cannot be deemed to be a legal duty in July 2025 or 26 or years together. But once there was an impasse, someone intervened.
At page 132, Mr. Bandyopadhyay, if you see the second last bullet
Yes.
point, it does not say that they don't want to or don't have the authority to. It says we have been busy with other commitments.
No, my lord, kindly, my lord, I'm sorry, my lord, kindly say the last line of the second line paragraph. Last line, that is important.
See the fourth line. However, due to prior commitments, members of the proposed committee have not been able to put their minds together.
Right. Right. And it is also, my lord, kindly lays emphasis on the word proposed.
Yes, Mr. Murthy. Yes,
My lord, a committee was proposed. The committee never took off. There is nothing on record for a committee. Which has never taken off, which has never seen the light of the day. Banking on that, stretching it to the extent, A, make a prayer B, kindly sees the nature of prayer B, my lord. This also I have indicated on last day at the cost of repetition, kind 66. 66, prayer B. Then I'll come to prayer A, but kindly sees prayer B first. A writ of mandamus do issue commanding the respondent number 1 and 2 to restrain the arbitrary and baseless modus operandi of the respondent number 5 until an independent committee comprising of eminent experts from film industry be appointed by this honorable court. This honorable court, not the one appointed by the government.
this has not been granted, Mr. Bandyopadhyay.
But it's not about being granted. But the question is whether this kind of mandamus can at all be sought from your lordships. But whether it comes under the ambit of 226 at all.
Are we hearing the writ petition finally?
No, my lord, I have come up against an interim order. But my lord, the
What sort of an interim?
interim order is, my lord, ultimately.
Respondent number 5 is not in appeal before us.
No. State is in appeal because the direction is upon the state.
Court has said that yes, I have seen your memorandum. I am also being apprised of the fact that there was a noble intent on the part of the government to solve the impasse. But however, for reasons to be recorded, review committee could not be constituted. And the instruction which you gave on the self-same date was that due to our prior commitments, we couldn't assemble. Now,
No, not us. Those members of the proposed committee.
Very good. Now, what did the single judge say? Single judge said that give both sides an opportunity of hearing and please come and tell me that what is the problem, whether I can solve it or not. You will not allow the court to say so much also.
First, the court ought to have
Now,
determined
correct us
whether
if-
there is a legal right
Your
and
maintainability-
corresponding to a legal duty.
Mr. Bandyopadhyay,
But at the
just a moment. Suppose the decision after perusing the report which is filed by the state, this court proceeds further that no, you have an obligation to solve this problem. At that stage, you can come and say that since you have made the maintainability point open, my lord, kindly consider this at this stage. But you are coming, you are presupposing something, and you are coming and trying to set an order that no, I shall not do it.
My lord, why I am doing so, my lord? Why I am doing so is because, my lord, in my understanding, the petitioners are not having the legal right
We will record
to that extent of even asking for this interim order, which interim order is not born out of these prayers.
Mr. Bandyopadhyay,
But it is
your
absolutely
argument-
enlarging the scope of the writ petition
No,
to
no,
the extent.
your argument was mandamus cannot be claimed in respect of B. We are not at that stage.
Right? Not only B, also A. What is A? My lord, kindly sees A. My lord, kindly sees A also. Kindly, my lord, sees A also, my lord, at 66.
Is it? Maintainability open it. Is it paragraph 4? Maintainability point. Yes, the first one. But we have got one zero. Maintenance point is considered only only Sagoda is the privilege. Sagodaর অবস্থা খারাপ মেইনটেনেবল তুমি তোমার ডিসকাশন দিয়ে মনে হচ্ছে আচ্ছা মেইনটেনেন্স করছে দেখি সরকার নিজেও তো মাথাটা ঘুরিয়েছে ঠিকই এটা রিপোর্টটা কয়দিন এটা
আটে কত হচ্ছে আটে ও আচ্ছা আচ্ছা ও আচ্ছা দেখছো
ওটা ওখানে that is not yet been decided. Yes.
Lord, I was also inviting your lordship to look into prayer A and prayer E. And not only B, but I was trying to emphasize B.
Mr. Bandyopadhyay,
take appropriate measure to ensure peaceful functioning in making films.
That stage has not come, Mr. Moody.
Then, my lord,
We will say
corrected. My lord,
we
the
will
stage of prayer E has come. That is the interim prayer. The stage of prayer E has come. That is prayer E, the interim prayer. The interim order for I'm reading at page 67 bottom. An interim order for formation of an independent committee comprising of eminent experts from film fraternity by the honorable court to ensure that the respondent number 5 would no longer be allowed to impose bans or engage in non-cooperation by giving instruction to its affiliates, associations, so and so, so and so, and so. But if this be the interim prayer,
interim period is review committee. That review committee shall ensure review
by the court. It is an independent committee by the court. Review committee is of July 24.
Until a
this is not the review committee. Kindly allow me to distinguish between the two. Review committee was a proposed committee in July 2024, which has not taken off. They want in this writ petition a committee appointed by the court to look into the fact that the respondent number 5 shall not obstruct the writ petitioners in making their film. This is the interim prayer, not the review committee. Kindly see an independent committee comprising of so and so from the film fraternity by this honorable court. Here I ask this question to myself that where the role of the respondent number 1 and 2, which is the principal secretary, coming to determine a future representation, because and why this question of future representation comes. Kindly comes back to page 132, because the instructing officer, which is the additional secretary who was instructing the advocate, they said in kindly take bullet number 1, why this question of future representation came at all. These are not born out of the prayer. 132. It is not in their prayers. They have not prayed for it. This is not the kind of interim order they want. But since the instructing officer said in bullet 1 that in the email representation dated 14 January 25, there appears to be no details were given of any pending work of the petitioner which has been hampered or obstructed. there are certain allegations against the federation of so and so and not against the state government. Since these details were missing in page 91 of the writ petition, the writ petitioners have been allowed to better the case by way of a future representation, which representation is to be considered by the principal secretary, and the order is to be placed before the honorable single judge. That is why I am saying,
Where is this? Where is this? 14
that
January.
is at page 122.
122. Oh, wow.
This was page 91 of the writ petition. And if your lordship sees, I was merely directed to take instructions on page 91. Now, the order preceding the impugned order kindly sees at page 125. The learned advocate who appeared for the state was asked to take instructions on page 91. 125 it is starting. The concluding part at 126, paragraph 9. Learned advocate appearing on behalf of the state respondent shall produce written instruction disclosing the steps taken in response to the complaint lodged by the petitioner annexed at page 91 of the writ petition. That instruction was produced page 132. And since the representation did not contain details, and since the additional secretary said that
this was the instruction given.
This was the instruction page 132. But the entire scope was changed that you file a future representation now.
Yes, Mr. Mojumdar, what do you have to say? Yes. You are also in the other two appeals also.
Yes.
I would
three appeals.
Same order.
Three appeals, same order, but two things are not common. One is this order at page 125, because this was only passed in Vidula.
I see. Those
two came in the interim interregnum between 30th March and 5th April.
20th March.
Yes, but all 14 matters were taken up together, and this order and the instruction at page 132 is common.
I see.
Common means it is though meant for Vidula, but the honorable Senator considered this order.
Same order was repeated in all the repetitions.
It was style order in all the.
But I am in Kingshuk and the other matter. But there are three appeals, 7 and 8. 7 and 8. So 7 and 8, my lord, I am appearing.
6, I am appearing.
6, my lord, Mr. Bandyopadhyay is appearing.
Other appeals also?
No, there are 3 appeals only.
14 writ petitions.
6, 7 and 8.
6, 7 and 8.
Yes.
My lord, may I?
Because Vidula I am appearing.
Yes, Mr. Whoever.
The
lordship will also give me that opportunity. My lord, I will just.
No.
Then, my lord, may I conclude my part, because Vidula, your lordship has to hear.
I'll not take much time, my lord.
Yes.
Kindly take, my lord, first, my lord, the review committee decision. My lord, kindly take page 102 of the stay petition. That is the expert. There was a total impasse, but one director was suspended from work.
102.
The relevant portions I am showing. This was what happened at the interventions of the Honorable Chief Minister. Kindly take the fifth line. The resolution followed an intervention by Chief Minister, Honorable Chief Minister Mamata Banerjee. Then such and such. After
Page 102 you are saying?
Yes. 102. It's in our page 70 of the writ petition. Kindly take the second paragraph, the one line. The resolution followed an intervention by the Chief Minister Mamata Banerjee. Has the lordship got it? Then, my lord, the fourth paragraph. After that meeting, directors and actors held another meeting at Technician Studio in Taligon, and after it ended late in the evening, some of the leading names in the Bengali entertainment industry came out and addressed a news conference. Then, going forward, the federations.
No, what were
there will be a review
committee was of 3 persons.
3 persons. Can you take last paragraph? There will be what was the decision? There will be a review committee chaired by Gautam Ghosh having Prosenjit Chatterjee, Dev, Indranon, 5 persons. Because Indranil Sheth is the Honorable State Minister of the Department of Culture and Information and Culture. Prosenjit Chatterjee, Dev, Indranil Sen and Arup Bishwas as initial members and representation from all guilds. That should be the review committee. This now kindly take. After that, no committee was constituted despite
So what is
intervention.
the date of this?
This was
31st July.
Yes.
All right. Yes.
Now, after that, we wrote, all the directors wrote who had faced troubles, then what the response from Gautam Ghosh?
এই যে পিট করে দিয়েছে আগের
Lordship says, my lord, I can. Well, this is, my lord, even they have, my lord, they have taken steps against renowned directors. They have suspended him, ostracized him. That was the case. That if they, my lord, they do not follow the dictates of these federations, they are ostracized. Those instances have been mentioned in the writ petition. 3 months was, my lord, one director was suspended, my lord, so-called suspension. 3 months.
By whom? By whom?
By these federations.
Exactly. That is a private issue.
Well, this is not a private issue. This is my livelihood. This is my work. This is my Article 91G. This is my 21. Now, some federation, this has some clout because they are the other association, the constitution of the federation. The federation is not a single individual trade union. They are the federation of various trade unions. Now, it is controlled by a politically influenced person. Now, he controls everything. So, if anybody defies the dictates of the federation, what this secretary does, that he asks nobody. Nobody should work. But one hairdresser even. This is not this Bidula. There are other directors, 14 had come. Now 2 have been pressurized to withdraw their petitions.
Yes. Now, what is the position in the writ petition? Court has proceeded further.
Court had proceeded after this order. We moved contempt against only the respondent number 5, not Mr. Bosu's client, Mr. And respondent number.
A writ petition has not been heard thereafter.
No, only contempt has been heard.
No, one interim order has been passed on 19th May, directing the principal secretary to approach local police station if there is any hindrance. Well,
hindrance
in their work.
Oh, I see.
If no technicians come, police is to be sent.
That's the 19th May order.
That is the summons substance of the order.
And kindly allow my
contempt. What was the violation?
But there is no contempt against state.
No.
Again, emphasizing the fact that we have no role. The contempt is against 5 private persons who are, I think, secretaries of different guilds.
Yes.
Hairdressers guild, cameraman's guild, so and so, so and so. The contempt, in fact, emphasizes that they know that
Mr. Bandopadhyay will have his turn.
No, I am not. I am only answering a query of the court.
I will confine my submissions.
Because just on 3rd April's order, there was the directions upon the respondent number 5 not to interfere with the work of the petitioner. That directions was violated.
So, violated, and you allege that another particular person has been instructed.
No, the federation is the other trade unions are the constituents of the federations. But government functions through its functionaries. The direction has been given the state government. Now,
no, who is Mr. Basu?
One of the constituents of the respondent number 5. One of the members of the respondent number 5.
Oh, he is a member of yours.
Respondent number 5 do not have natural persons as members. My members are
with other secretary.
Yes.
Mr. Basu represents the institution. Members are natural persons.
Representing someone. So he is an association and a part of your.
He's an affiliate to my federation.
May I?
There are 23 such associations or trade unions.
It is like this classically.
If anybody violates directions, she or he will be out of court.
The petitioner is acting in serious, is acting in.
And we will come to that. Let me make my submissions, my lord. Let us not, do the hair splitting exercise over hairdresser. Let us come to the core issue. The core issue arises in this writ petition is in this appeal rather, as to whether writ petition is maintainable or not. What should I say? The sheet anchor of this appeal is an instruction given to the learned counsel appearing for the state, which was produced and submitted before the honorable single judge. Kindly take my appeal, if your lordship so pleases, my lord. Kindly take my lord King Shuk De. Number 857. I'm so sorry, my lord. We should have.
Document এখানে পাওয়া যাবে না?
We don't have that document here which you are relying.
It is there, my lord. I don't have the page number, actual page number. But my lord, the
Now tell us what you are wanting us to
page গুলো মিলবে না, না? Page গুলো
এদিকে তুলে দাও।
না বলছি
Tell us,
Yes,
tell us the
tell us
date.
where-
Tell us the date.
My lord, kindly take, my lord, in this case, so far as my lord this Kingshuk Day is concerned, the instruction your lordship will find at page 161. This is the same instruction.
161.
161.
Bidula 132.
In Bidula, it is 132.
Hmm.
But we will give
It's
the
the same document.
we will give the corresponding pages.
Yes,
Well,
yes, yes.
Instead of my lord traveling or lordship, we will give the
Yes,
corresponding.
yes,
It's not necessary. My lord, kindly take some of the dates. My lord, kindly take it from me. Whatever I am relying on is part of the appeals in all the cases. My lord, it is like this, my lord. Federation, my lord, when we were children, when we used to read, my lord, these Ladybird classics, there was Greek mythology. It's like that Hydra. It's the Hydra with so many serpents.
How many heads?
Yes. Again here, man. Again here. Yes.
One serpent with multiple
Yes.
heads.
But Heracles has to come. But we hope the court assumes the role of the Heracles.
But you are the
So, my lord, now the question arises is that some of the dates which I take your lordship to, on or about, well, kindly take it from me. I think my learned senior standing counsel will not object to this. On or about 30th July 2024, when there was an impasse in the film industry, working of the film industry, my lord, the Honorable Chief Minister intervened with other ministers, namely the Minister in charge or Minister of State, Minister of State Information and Cultural Affairs, and also some other ministers, and also, my lord, some of the bureaucrats, to, my lord, put an end to the impasse. My lord, the result of the meeting was that we would form a review committee which would address all the issues or all the problems which are faced or will be faced or may be faced by the different actors, I mean different technicians, directors, actors in the film industry. Review committee was not constituted. We wrote a letter to Mr. Gautam Ghosh, who was supposed to head the review committee. Gautam Ghosh replied to us, yes, there was an informal meeting, but there is no formal notification. So I cannot act. But the question, the pertinent question came from lordship is that what will I do if there is no notification? How the state action can be challenged? My action is not an overaction on the part of the state. My writ or my petition is alleging inaction on the part of the state respondents. It's all about inaction. It's not about overaction. It's not about administrative excess. It is about inertia, which the state respondents have adopted in this matter. Now, my lord, then kindly mark the dates. My lord, on 8th of October, this Directors Association of Eastern India Center mail to Mr. Gautam Ghosh regarding formation of committee. Now, my lord, now Gautam Ghosh replies. That is very important, my lord. Gautam Ghosh replies
8th of October, letter by whom?
My lord, we wrote to Gautam Ghosh that please act. My lord, Gautam Ghosh replies, but which your lordship will find, my lord, the page may be slightly different. Sorry, 121.
Yes,
121 of
that has been shown to us.
And that has been shown to your lordship.
Yes.
So, my lord, at that stage even, no committee was formed. But, my lord, continually, for last at least 1 year, my lord, let us talk about from July 2024, continually all the major players in the film industries were subjected to this kind of harassment and were made to face obstacles while running the film industry. Now, my lord, now question arises that Mr. Bandyopadhyay rightly points out that why mandamus would be issued when there is no public duty to be discharged. Because mandamus could only be issued when there exists a public duty. My lord, I take the opportunity to place on record. This is a printout from the official website of the Information and Cultural Affairs Department, which, my lord, Mr. Bandyopadhyay would not deny the existence thereof. Kindly take. এটা annex করেছিস? হ্যাঁ, পুরোটা annex আছে। কতটা আছে? Kindly take, my lord. It's a better printout. Kindly take. Kindly take this one.
Page 147.
Page 1. Kindly take, my.
That is page 147 of Vidula.
Kindly take, my lord. Page
Annex.
1. Vidula. Okay.
তোমারটা তো আছে?
Kindly take, my lord, for once.
Yes.
এই আমাদেরটাই নেই বোধহয়। My lord will kindly take page 9. Well, this is from the so the existence of this particular document is admitted by the state. Directorate of Films. Mardas got that?
That's at 136.
Well, it's not there in my appeal.
Yes, so ours is at 136.
136.
The
I'm
relevant
sorry.
portion is at
Internal page
147.
9 is at 147.
Yes. No problem.
Yes.
But my lord, your lordship will get the better copy, my lord. So, my lord, now your lordship will find this is Information and Cultural Affairs Department, Directorate of Films. Now, my lord, kindly take page 9 of the bunch of this document. If it is 136, it should be 145. Subject to correction.
Yes.
145 your lordship has got. Kindly take West Bengal Film Academy.
Yes.
147. 147, I'm sorry.
147 in Vidula.
Huh. My lord, may I just kindly take the office address?
121, 120. No.
Yes.
This is Nabanno. One, but the most important thing is that kindly take the mandate of the Film Academy. My lord has got that? My lord has got that? May I just read out the mandate? To my lord, Mr. Justice Chakraborty, your lordship has not got that? Kindly take page 9.
Page 147.
My lord, this is more legible because that's a web print and this is a smart print. It's all the same.
This is not in page 9, no? 147.
147.
Referring to page 9.
Page 9 of this document.
Yes. Where is the mandate of the you are reading?
My lord, it is page 9. It should be page 9. May I just kindly
Form in the page 147.
Oh, yes.
My lord got that page 9 it is.
Out by Mr. Majumdar, the orientation is a bit different.
All right. Yes.
My lord, may I just take your lordship through this particular mandate of the Film Academy? The mandate of the Film Academy is as follows.
Now, this Film Academy is who is the chairperson?
My lord, that is not disclosed in the website. They have the registered office at Nabanno, but who is the chairman, who are the members of the Film Academy, it is not available in the website. Whether it's a paper academy or not, I do not know.
So these papers, you want to show that state is having an overwhelming power to control. all-
Yes, yes,
This is your
yes,
argument.
yes, yes. Kindly take this document.
Yes, yes.
My lord, the mandate of the film academy.
Chairman করেছে, West Bengal Film
রেজিস্টার্ড অফিস হচ্ছে ব্লক বিহার সেক্টর 5 পরের কথা কোন ব্রিফটা উপরে লিখে এই ব্রিফটা চালাচালি করার উপরে এসবি বলে লিখিয়েছেন বিদুলার ব্রিফ আছে
এই যে ব্লক জিএন সেক্টর
এটা তো রূপা এই যে আগের কথাটাই যেখানে ম্যান্ডেটটা মার্ক করে কেটে ফেলবে কিন্তু এটা হচ্ছে
নমন
এটা ব্রিফটা আমাকে দিয়ে রেজিস্টার্ড অফিস হচ্ছে নরমাল
হ্যাঁ
আর
নেম এন্ড ডেজিগনেশন ওটা করতে হবে নেম এন্ড চেয়ারম্যান ঠিক আছে
এই যে film academy
মেম্বার সেক্রেটারি এন্ড কনভেনারের
এখানে পাবি না ওয়েবসাইটে ঢুকতে হবে মানে may I just take your lordship through this document?
That is your come to the any other point.
No, my lord, kindly take 3 bullets only of this particular document.
Yes.
To encourage and promote development of films, to act as an umbrella body thing for all issues related to film industry.
Yes.
To promote and develop film related infrastructure in the state. And the 4th bullet is perhaps the most important bullet, to advise on suitable policy interventions on issues related to the film sector, including constraints faced by directors, producers, exhibitors, and others. This is a clear case of constraint which we are trying to make out before the Honorable Single Judge in the writ court. And my lord, there has been a complete inaction on the part of the state.
Mr. Mojumdar, show us that this West Bengal Film Academy is under this information and cultural
Yes,
affairs.
take the first page, my lord.
Yes. First
Indisputably, let them deny that. Let the state deny that.
it is under the directorate.
It
of
is
Films,
under,
or
my lord,
it is-
kindly take the first page. The first page is like this. Information and Cultural Affairs Department, my lord, the internet in this particular courtroom is very bad. My lord, so I could have shown it from the my lord, this website even. Information, yes. Well, kindly take.
It's a special internet. You cannot say that it is.
Yes, my lord. Yes, my lord.
You are enjoying special internet. Bad bolt.
My lord, they are admitting that this academy
Is under
Information and Cultural Affairs Department.
Yes, yes.
So, my lord, kindly come to the 4th bullet I was reading.
Yes, you have shown us.
Then 5th, to promote welfare of artists, technicians, and other professionals of the film industry. Then, my lord, then it is about mediclaim and all that, and this is there. So, my lord, now the question arises that the intervention made or intervention caused in July 2024 is in sync with the object and purpose of the Information and Cultural Affairs Department. When the state assigns to itself a duty to protect the interest of the film industry, all the major players or the minor players even of the film industry, then that duty acquires the status of public duty. Point number 2. Point number 3, if it is a case of public duty, then for enforcement of the public duty, indisputably mandamus would lie. Leaving aside the other part of the argument, now it's a clear dicta by the judgment rendered by the Supreme Court that if it is a case of violation of 21, state is otherwise required to protect. There are 3 articles, 3 clauses in play. By Mr. Bandopadhyay referred to 19(1)(g) and 21. I add one more clause of 19, that is 19(1)(a). It's a clear case of violation of 19(1)(a). Freedom of expression is being throttled, and the state is maintaining an inertia, a stoic silence.
Yes, all right, thank you. Anything, anybody else to make submission?
My lord, my prayer before your lordship is that
No.
let the matter be decided on merits. My lord, it is my respectful submission before your lordship. Having regard to the scheme of this entire document, state is undoubtedly required to protect the interest of the filmmakers or any other player in the film
But
industry.
unless the maintainability point is decided by the learned court below,
Yes. My lord,
suppose a report comes today,
yes.
and the maintainability issue has to be addressed by the learned.
My lord, your lordship, this appeal is all about maintainability only. Your lordship would decide whether the writ is maintainable or not.
No, why should we decide that?
Then my lord, kindly remand it back. We will argue it before the writ court. We don't mind, my lord.
Yes, Mr. What you want to say?
The only thing, Lord, probably this is not so sanctimonious as it is being projected before your lordships. It's a writ petition engineered by certain producers. This will appear from pages 40.
One more thing, I'm so sorry. A second, Shomuda. One averment is very important of the state. I'm so sorry. I missed it out. I'm so sorry. I'm so sorry. But kindly take this averment made in the stay application. This is very interesting, my lord. This is at page 12 of the stay application, subject to correction. Sorry. Yes, page page 13. But kindly take what stand state is taking against this petitioner. Much submissions have been made regarding consideration and what is the fallout of consideration. Kindly take this paragraph. It is pertinent to note that there are several instances where paragraph Roman 15
in your petition.
in my petition. It may be identical in all the petitions.
No. Page 13 নিচে না।
ওটা আছে বিদুলাতে, in Bidula it is page 12 para 15.
It is para 15, Roman 15.
Yes.
It is pertinent to note that there are several instances where unscrupulous petitioners with the connivance of pliable authorities have misused the direction to consider issued by the court. A claim which is stale, time-barred or untenable is put forth in the form of a representation. On the ground that the authority has not disposed of the representation within a reasonable time, the person making the representation approaches the High Court with an innocuous prayer to direct the authority to consider and dispose of the petition. When the court disposes of the petition with a direction to consider, the authority grants the relief, taking shelter under the order of the court, directing him to consider the grant of relief. Instances are also not wanting where authorities unfamiliar with the process and practice relating to writ proceedings and nuances of judicial review have interpreted or understood the order to consider as directing the grant of relief sought in the representation and consequently grant reliefs otherwise ought not to have been granted. This is a stand in this kind of petition, as if unscrupulous litigants are before your lordship, and that too by the state. This is, my lord, vitriolic.
Yes.
These are my respective.
Yes, Mr.
No, but the entire grievance against my client is with regard to laying down service conditions through settlements.
So what you want to argue? You are arguing in support of Mr. Bandyopadhyay?
Yes.
Yes.
Not one of the petitioners who had filed the writ petition before the Honorable Single Judge is a signatory to a settlement which lays down service conditions of senior workers. Please have a look at page 97
Of which petition?
of the Bidula's petition.
Page 97.
Yes, running page 97.
I'm taking your lordships kindly, madam.
The self-same petitioner does not come up before this honorable court ventilating her individual grievance. She does not say when did she last produce a film or last directed a film, whether it was a telefilm or a movie, etc. She seeks to ventilate a cause. to which note there are only 12 addendum. 12 persons have come forward to add to her cause out of a possible 1,000 persons. Please come to page 97. Who is the signatory?
This argument is for maintainability, Mr. Mojumdar.
Please.
But we are on the issue as to whether the learned judge did the right thing in asking a report from the state. This is the subject matter of appeal.
Report from the state with regard to these. A decision to be passed on these.
That is not. That is
Please
not
come to page 130, 130. The grievance boils down to these service conditions which are governed by settlement, signed by one of the writ petitioners. Please come to page 130, paragraph 18. Upon hearing the parties and on perusal of the documents annexed to the writ petition, it appears that an impasse in the film industry did take place for which the Chief Minister was required to intervene, as the petitioner raises certain issues with regard to their right to carry on profession independently. Accordingly, the petitioner is granted leave to file comprehensive representation highlighting all grievances before the Secretary. But pages 44 to 46 of the stay application principally deal with these service conditions governed by the existing settlement. But senior workers were being paid for 8 hours duty while they were being made to work for 18 hours a day.
This agreement was with whom?
But please come to, I just showed to your lordship. Now this is at page 97. It begins at page 94 is one of the settlement. Between the Federation and WBTP.
Page 94.
94. It begins at 94.
97. English term 97.
The English version is at 97.
Conduct members and staff of federation. This federation is your federation.
Yes.
Code of conduct for members and staff of federation means the writ petition.
Associations members. We have only institutional members.
No, this is under respondent number 5.
Respondent number 5
enters a federation. It is a code of conduct for members and staff of federation. Which federation?
Federation is respondent number 5. Respondent number 5 does not have a natural person as its member. So all the trade unions or associations authorize the federation on behalf of their members to enter into agreements or settlements.
All right. Yes.
Now, Lord, please see who was one of the signatories on behalf of the employers, a writ petitioner. And these are all laying down service conditions, working hours, overtime duty, tiffin, how many, when should the floor work be conducted, all these things. All led to service conditions.
Yes.
This has probably attracted the ire of some very few producers. Your Lordship will get the smoke screen from page 44. It's not a director who is really not approaching the court. Because when the directors are producing or when the directors are acting in films, they don't have any grievance. But some of the petitioners are actors also. They are acting in films produced by some of the producers to which they have no objection in complying with these service conditions because that is beneficial to them. Now please come to page 44.
Yes.
Paragraph M. The FCTWEI, that is the Federation, had also created an arbitrary dichotomy by reckoning the work time for their technicians. From the time the technicians assembled at the studio, whereas the other regional film industries, the same was computed from the time when the technicians reached the shooting spot. But these things have been directed to be decided by the state. Without any prior consultation with the directors or producers of DAEI, the FCTWEI had several times announced for closure of shoots in an arbitrary and capricious manner on rescheduling of the call time based on various programs it sponsored or organized.
All right, Mr.
Not only the producers can be aggrieved by that,
Yes. Anybody else? Yes, Mr. Basu, what you are wanting?
My grievance is this, my lord, that without making us party, my lord, allegations have been made against us in contempt, my lord, we have been implicated as an alleged contemptor. My lord, I did not file an application. I sought to intervene. Your lordship, I am
You are intervening on whose behalf?
intervening on
Who is the
Trade Unions
contemptor?
Association.
trade union, different trade unions, my lord. The senior and video are,
In contempt, you must have been implicated
yes,
as a
yes, party, and without
named party.
named party, but I am the secretary president of an organization. Now, my lord, our organization is senior and video artist, cinematography, cine production managers,
Cine
cine and video assistant directors, Guild of Eastern India. Cine and Video Assistant Directors Guild. Now, my lord, next it's Eastern India Cinematographers Association. That is, my lord, the second. And third, my lord, Cine Production Managers. And then
you are on behalf of the association Cine and Video Assistant
Directors
Director
Guild.
and any other person.
Yes, other also, my lord. That is, my lord, Cinematographers Association. Then, my lord, Cine Production Managers Association.
All right, you please give
Now,
us.
my lord, I will, my lord, I will make a
You will give us the names. We can
names,
get
my
the
lord.
names. Yes, yes. You
Kagoje
can.
likha- I'm
Your argument.
You know, my lord, first of all, my lord, whether I am required to make any application on the conspectus of the facts, my lord, that have been narrated to your lordship just now by the state as well as Mr. Mujumdar, learned senior advocate, Mr. Bandyopadhyay. Now, my lord, the question is, my lord, court, my lord, without any application, because the lease has to be decided between the parties, my lord, if at all lease is maintainable, my lord, without any application, court, that is the principle order 1, rule 10(2), subject to correction, my lord. So today, my lord, he is seeking order. What is the, my lord, execution of constitutional reasonableness, my lord, they have asked for, my lord. Because, my lord, the Cine Film Academy, which Mr. Mujumdar, my learned senior friend, has, my lord, sought to draw your lordship's kind attention, my lord, from the website. My lord, did he make any application to the authorities, my lord, constituted under this website or the act, assuming, not admitting? But he did not make any application. There was no case, my lord, made out.
Representation was to the principal secretary.
No, my lord, the question is that he said, my lord, the Film Academy was constituted as per the website. The clauses, one of the clauses he has read for my lord's attention, my lord, it said the all disputes.
Right.
Question is, my lord, no application was made before
Yes,
the Film Academy.
not
No,
to the Film Academy, but to the
but
official.
he is
council.
now, my lord, trying to make out a case that Film Academy, my lord, was under obligation or duty to address the issue. My lord, essentially, my lord, from Mr. Bandyopadhyay's submission, Mr. Sagar Bandyopadhyay, my learned senior friend, my lord, that essentially, even if it is a private dispute, he has admitted it is private dispute. So question is, my lord, my lord, said, my lord, that even if it is a private dispute, my lord, that Article 19(1)(g), my lord, will come into play. Question is, my lord, this is not executable because, my lord, this is a trade union. I am a registered trade union. Cinematographer associations, cine video associations, we are, my lord, registered trade unions. My lord, there was a time, my lord, we had to, my lord, withstand, my lord, the pain of hunger, my lord, because there was no actual wages. The federation, my lord, the moment, my lord, it was constituted, the entire, my lord, the salaries, wages, my lord, that were increased through negotiation, not through, my lord, any, my lord, the kind of movement, my lord, he is saying. And there was no case out.
Mr. Basu, there was a direction that you should not disturb. That
My lord,
was
question is, my lord,
on the basis of that contempt file, impleading you.
impleading me. I was not a party.
Have you challenged that writ petition order?
No.
Which was upon the federation?
No, my lord, I am not. My lord, I
You are
did.
an association.
I am an association, my lord. My
So
secretary.
you go and challenge that order.
Question is, my lord. Question is, my lord. The first question, subject to
Which
correction.
was the direction which was passed upon him, alleging violation of which the contempt has been filed.
My lord, the contempt, my lord. The
Contempt has been filed alleging violation of such direction.
of the order, my lord, passed on a writ petition where I was not a party.
That is why that makes a ground for challenging appeal against that.
But the question is, this appeal.
Please answer our question.
No, my lord,
Whether
my
you
lord,
have
I did not. Kindly, my lord, this is the order.
Which is the order?
Paragraph 23.
Date of that.
Respondent number 5. The order dated, my lord, 3rd April 2025.
Thank you, madam.
Yes.
Third April,
Page
yes.
130.
Yes.
Yes.
3rd April, yes.
If what is the direction?
Number 5 is received.
Right now, my lord, but my clients were made parties in the contempt, and my lord, the court is adjudicating
So
upon.
you in contempt an allegation has been made. You are not disputing that you are a member of the respondent number 5.
Correct.
But you are not inextricably bound with the respondent number 5 that whatever the federation says, you can hold me guilty. We can understand that. Then you ought to have challenged this direction. Neither the federation nor any association under the federation has challenged this
My lord, I
direction.
bow down to your lordship's observation, my lord.
Please
No, my lord.
tell us that on why haven't you, your contempt will vanish once you get an offer, because respondent number 5 is not in appeal.
Respondent number 5 is not in.
But when the court directed that giver consider the representation and pass, that was a sort of an innocuous direction
Yes,
according
my
to
lord,
them.
my lord, I'm extremely grateful,
So,
but
Mr.
since
Basu, unless you challenge this, how can you
Lord,
get yourself
my lord,
out
this
of
is,
the
my lord,
contempt?
I'm extremely grateful. I have no explanation to offer to the questions, my lord, that has fallen from my lords. But the question is, I am raising a very fundamental, elementary question
You can
to
go
my,
back
put to myself.
go back to the learned single judge and say that I was not a party.
My lord,
Allow
it is
me to
my lord,
challenge
that is
decision.
what the basic principle is, my lord, order 1,
Forget about basic principle. There is an order standing. Suppose if I had been the judge, I have created respondent number 4 is to required to do that. And in the contempt, they make a member of that association as a
The court did
contemptor.
not proceed with the learned single judge, my lord, did not proceed with the contempt. My lord, last submission. কতগুলো
Yes. Yes, Mr. Basu.
Yes, Millard, Mr. Mojumdar, my learned senior friend, as well as Mr. Sagar Bandyopadhyay, my learned senior friend, Millard, while making their submissions, Millard, did not apprise this honorable
They
court.
are leaving the courtroom. You are so influential. You have started arguing and they are leaving the courtroom. They are really afraid of you.
Millard, it
They
is,
cannot meet your
Millard, it is their perceptions, and your lordship knows, Millard, perception is frightfully narrow, Millard. So, Millard, I respect their choice, Millard. Millard, I am not worth listening. Kindly, Millard, so far as Mr. Bandyopadhyay is concerned, Millard, Mr. Bandyopadhyay has not made out a case. Neither Mr. Bandyopadhyay's client nor Mr. Mojumdar, my learned senior friend's client. Millard, they did not, Millard, place any data which shows, Millard, at least, Millard, from 2023, 24, 25, Millard, how many, Millard, the OTTs, how many films, and Millard, the serials, TV serials. So, Millard, where is the element of hindrance? I put this question. They have made out a case, Millard, that they are right.
What we are saying, that he has done this, you ought to have preferred a leave to appeal.
Millard, question is, Millard, that if Millard, the principle, Millard, 53 of the REIT rules, it says, Millard, the principle of civil procedure code applies.
We have heard you. We have heard you. It is not that we are shunning you.
No. Millard, the question is the whether I am entitled. Millard, I put this question to myself. There is elementary that while court has passed this order, honorable single judge, whether the honorable single judge, her ladyship, ought to have considered this basic, Millard, order 1 rule 10.2, that her ladyship, Millard, wanted to pass an order, Millard, for the sake of the security of a citizen, Millard, who had approached this honorable court. Question is, without making us party, and the order has been passed, and I'm a party. The defense, Millard, the next submission might come, Millard, that if I have a knowledge of the order, Millard, it is sufficient to draw a contempt proceeding against me, even if I am not a party.
It is.
It is. So today, in the name of, Millard, the
আমি জানি না কি মেম্বার না একটা অ্যাপ্লিকেশন আছে yes
Millard, this is my submission.
Reply?
Two lines reply.
my lord, Mr. Mujumdar's submission was based on, my lord, that Film Academy website printout, my lord. If your lordship kindly take page 147. But in the brief also it's there, my lord. I have annexed it because I have disclosed, I have shown the pleading also. Why I have disclosed his document. But I come to the pleading later, my lord. They have placed it before the Honorable Single Judge, I have annexed it. It is not something I would rely upon.
No, just one. এখান থেকে এইটার মেমো
এই আমরা কাদের হয়ে রিপ্রেজেন্ট করছি জজ সাহেব চেয়েছিলেন
না আজ পেয়েছি
আপনাকে লিখে নিন
ও আচ্ছা ইয়েস এটা একটু হারিয়ে না যায় এই অর্ডারটা ডিকটেশন দেবো যে অনেক Yes, what you have
147. Lord, my learned senior, Lord, Mr. Mujumdar had relied on, Lord, page 147 to show the aims, objects of Film Academy, West Bengal Film Academy. Kindly see the bottom of that page. 147, name and designation of the officers. Lord, there are two office bearers have been mentioned. One is the chairman of the West Bengal Film Academy, and one is the member secretary and convener West Bengal Film Academy, who is also the ex officio director of films.
No, you are saying that this
147
is not under an government, it is not under the
I am not
department.
denying it. It is under government. It is constituted by the government. The office bearers are chairman, West Bengal Film Academy, and member secretary and convener, who is ex officio, the director of films. Is there at page 147 in their document. Now kindly take 122, which is the plinth of the writ petition. That representation at page 91 of the writ petition, which is annexed at 122 of this stay, my lord. I have placed it before 122. Kindly see whom it is addressed to. One is the secretary of the department, 122. One is additional secretary and ex officio director of films, and three is Indonesian. Neither the, my lord, member secretary is addressed, nor the chairman of the Film Academy addressed. A new case being made out by showing this printout of a website. They never approached the Film Academy. They never resorted to the Film Academy. Now assuming they wanted to resort to the Film Academy, but they did not understand whom to address it. Kindly take, my lord, my pleading where I have annexed this document, their document. Kindly take page 11, para 14 of the stay application. Paragraph annexing this document. On 19 May 25, when the writ petition was taken up for consideration by the Honorable Single Judge, one of the petitioners submitted, that is Mr. Mujumdar basically, one of the petitioners submitted a document published by the applicant number 2 herein on its website. The document submitted by the writ petitioner before the Honorable Single Judge during the conjoint hearing before the Honorable Single Judge 19 May, as per the submission of the writ petitioner, evinces that the respondent number 1 writ petitioner has an efficacious alternative remedy available for redressal of her grievances. However, despite there being an alternative remedy available to her, as per her own contention, the respondent number 1 writ petition has not availed of the same. A representation which was nowhere meant to be to the Film Academy is now suddenly being picked up. A website printout is being picked up to make out a case today when the appeal has been preferred. When the representation from the representative, your lordship will not find any utterance, any mention of Film Academy. And my lord, the other paragraph that Mr. Mujumdar emphasized, that is the very next paragraph, that is Roman 15, where my lord, they have been called to be unscrupulous petitioners, etc. My lord, your lordship knows, my lord, that is, my lord, the principle laid down, my lord, in APR SRTC versus Srinivas Reddy 2006 3 STC 647, the judgment delivered by Justice Ravindran, sitting with Justice R.D. Prasad. That is the principle.
That?
That is a Roman 15, which Mr. Mujumdar was aggrieved by, that why will state make this pleading? That is the principle of law laid down in 2006, volume 3 SCC 674. Judgment passed by Justice Ravindran, sitting with
Yeah, what
Justice.
is the ratio of that?
The ratio is that but all representations, any representation cannot be directed to be considered, as that will give rise to a fresh cause of action. The authorities will keep passing an order and they will keep challenging it. If your lordship sees in that paragraph, I'm reading, your lordship need not see, I'm reading it for you. In that, it is there in the judgment also, paragraph 17, paragraph 19, I'm sorry, that instances are also not wanting where authority is unfamiliar with the process and practice relating to writ proceedings and nuance.
Which para you are?
Paragraph 15, which Mr. Mujumdar read.
Yes, yes. No.
So the bottom middle I'm reading at page 12. Bottom middle I'm reading. But I am reading from the middle. When the court disposes of the petition with a direction to consider, the authority grants the relief, taking shelter under the order of the court directing him to consider the grant of relief. Instances are also not wanting where authority is unfamiliar with the process and practice relating to writ proceedings and nuances of judicial review, have interpreted and or understood the order to consider as directing grant of relief sought in the representation and consequently granting reliefs which otherwise could not have been granted. Thus, action of the authorities granting or deserving relief in pursuant to orders to consider or the claim or on account of collusion connivance between the person making representation and proper person. So, your lordship, that is why at least prima facie, your lordship will see that what is the grievance that is to be determined by the authorities when the direction within quotation to consider has been passed. Your lordship may not go into the entire merit of it, but at least prima facie.
All right. Thank you. So we will take up all the three together, or all we will pass the order at 2 o'clock. Take it all. Yeah. Chupan. বলছো তিনটে কস্ট টাইটেল দিয়ে দেন।
Your Lordship, I'm seeking for a short adjournment for today.
Let us hear Mr. Chatterjee.
Lord, there
I am appearing for the state led by Mr. Bimol Kumar Sai.
Lord, if your Lordship sees, Lord, there are two appeals. One is item number 9 and the other one is item number 10. Item number 9, my lord, is their appeal, where, my lord, they've challenged an order, my lord, passed in the writ petition filed by us. Where, my lord, the Honorable Single Bench was pleased to pass an order that wherever I am, my lord, in possession, the other side should not throw me out of possession, and the police was given a direction to that effect. They have challenged that order, my lord. They were violating that order. That is why, my lord, we filed a contempt. In the contempt application, my lord, the original order which was passed by the writ petition, that was modified. In my appeal, my lord, I have challenged that order.
Modification.
Yes, sir.
Practically, my lord, my appeal therefore becomes infructuous because, my lord, the order, the initial order which was passed has been diluted to a great extent such that my lord had to prefer an appeal against that order.
So we will record that your appeal has become infructuous.
Only, my lord, there are certain observations which, my lord, are, my lord, I have to, my lord. So, my lord will hear my learned friend's appeal. My lord friends,
Submissions will be different.
So, my lord, may I?
If their appeal, if they say that their appeal has become infructuous, then my submissions will be very different. My lord records that, and I make my submission.
Then in
on
that one, may I make my submissions, my lord? My lord, what the initial order which was passed in my learned friend's writ petition was twofold, my lord. First, it said the petitioner is directed to reconstruct, notwithstanding the fact there are civil suits pending between the parties.
This is the first time it is appearing before us.
Not for the first time.
Order has been passed.
No order has been
Your
passed.
Lordship wanted us to serve them, give them notice that they are not appearing. my lord.
Only on the last
So
day I could
in
not
view
appear.
of such, are you playing in any interim order?
No.
Not
There
really.
is no, my lord,
Scope
But
of
you can fix a date for hearing.
So we will admit your appeal. We will and we file your paper books. We will fix
Very
the
well,
date.
I will do that. In fact, my lord, both the appeals.
Will a single set of paper book suffice for both
Yes.
appeals? Then let's do that. It will be convenient.
কি অসুবিধা একটা সিঙ্গেল সেট অফ পেপার বইয়ে দুটো যদি appeal বানিয়ে যদি করা যায় কি
My
অসুবিধা
lord, may I separate appeal? Separate paper. Separate paper.
appeals but very connected. So one set of one paper book will in 2 volumes, I don't think should not be a problem.
Was it hard upon exchange of affidavits?
It was.
Oh, both the
Yes.
My lord, I think separate paper book would be better.
I don't have a problem with it. It's up to Mr. Jain. I don't have a problem.
You were trying to make it.
And in the meantime, nobody touches anybody. That's the only thing, which is required.
But that's
Because
interim order.
To touch him.
He is trying to.
Perhaps that, my lord,
He
would
is
be an
trying.
interim order which my lord friend
Your
said is there is no scope.
What happens is that during the pendency, things start happening. And that is where the problem is.
Mr. Show us the parent order.
115 of the
If my lord is taken MAT 381, it is at page 115, my lord.
381.
Page
115.
115.
That's my appeal, my lord.
So, Mr. Chatterjee, there is status quo of the civil court.
That was again modified in the contempt matter.
There's another history to this, my lord.
And
There's a
that is
demolition
exactly why I say, my lord,
order that
they
I
are-
obtained, which is pending before the Supreme Court. Supreme Court has directed status quo. So that's, my lord, lot of litigations are going on.
That's in a demolition proceeding.
In respect of the same property, my lord.
So there is no problem. My learned friend says, well, that status quo order is there. Records that.
That's on demolition, directing the KMC not to demolish in the meantime, my lord. But, my lord, any further order, my lord, I don't think, my lord, I'll have to oppose, my lord. Any further prayer, my lord,
Some
makes,
plausible reason.
because they have they're in an illegal constructed area. I have an order of division bench directing demolition. This was challenged in SLP, where the Supreme Court said.
So, Mr. Singh, we will record that there is a status quo operating by the Supreme Court in connection with the property involved in your writ.
With regard to demolition, my lord, of a property.
All right, with regard to demolition,
That can be recorded.
in view thereof, we are not passing any interim order in your matter. Finished.
In any of the appeals.
No. In your appeal and in his appeal, we will record that there is no scope for issue.
Right.
So, what do you say? Do you find a joint paper?
Let there be separate paper books.
I am for the appellant, praying for the adjournment, my lord.
You are for the
Adjournment for the today.
appellant?
Appellant.
Yes, madam.
I am praying for the adjournment for today.
Why adjournment, madam?
The advocate on record is not present here.
So you are here. Tell us. You have, when did you join?
2022, 2023.
23. Open the order impugned and place it before us. Let's try. If we are against you, we will give you time. Oh, original site কটার সময় আছে?
Yes.
The order is in your memo of appeal. Which order are you challenging?
My lord, the order is passed by Honorable Justice Amrita Sinha on 5th of April 2024.
Yes, place it. What is your name?
My lord, Dhriti Dash.
Das.
Dhriti Dash.
Who is your senior?
Mr. Dilip Kumar Shah.
Dilip Sannal.
Deep Shah.
Oh, Deep Shah. Deep Shah.
The petitioner is a doctor, and he was functioning as a doctor under Southeastern Coalfield Limited.
No, please read the order which you have challenged. 5th of April 2020.
Petitioner took a loan from the West Bengal State Cooperative Housing Federation Limited in the year 2006 for construction of dwelling house. The said loan amount has not been liquidated till date. The petitioner submits that there are genuine reasons for not being able to pay off the dues. According to the cooperative society, a sum of rupees 22,23,314.62 62 only is due and payable by the petitioner. The board of the directors of the cooperative society arrived at the aforesaid figure after consideration of the request made by the petitioner by waiving the penal interest. The petitioner is aggrieved by the amount that has been fixed by the cooperative society. Learned advocate appearing on the for the register of cooperative society raised an issue with regard that maintainability of the writ petition before the court. It has been submitted that it is an absolute private arrangement between the petitioner and the cooperative society. The issue may be decided by the competent civil court. From the submissions made on behalf of the parties, the court is not satisfied with regard to the maintainability of the writ petition. There are several dispute questions of facts and figures. There are to be adjudicated. The same cannot be done in a writ proceedings. It will be open for the petitioner to approach the competent forum for relief.
So why you are aggrieved?
The point of maintainability of the writ, this is
How much amount will you pay?
I will pay, my lord, the amount I have taken. I can able to pay that amount, not the interest.
What is that amount? They have waived the interest. They have waived the interest. They are claiming 22 lakhs. You are a doctor.
22 lakhs, including the interest also. There are also a lot
Penal interest waived.
Not penal interest, my lord. I am not able to this current. My situation is I am very much ill. I am also disabled, and my wife is also disabled.
So when did you take the loan?
One is taken.
মোটামুটি ঠিকই বলছে
Uh,
একটু ডিসপিউট রেজ করতে পারে মিটিয়ে দিতে পারবে you are the cooperative society.
মানে society but my lord, this is West Bengal State Cooperative Housing Federation Limited.
Oh, I see.
Society has been, the term society has been used, my lord, it should be house fed. State housing, my lord, I am representing, my lord, the
Now, very good. He took a loan from the board.
board.
Oh, not from any cooperative
No,
society.
not from any society.
this is the difficulties.
So why you have said that go for a dispute? It is a dispute between you and him. You are a federation.
My lord, federation. Well, there is no dispute at all, my lord. Kindly, my lord, takes up the, my lord, the petition itself, my lord, the writ petition.
No, why do you say no dispute?
My lord, because, my lord, they have, my lord, not raised any, my lord, any point in the writ petition. Only thing is, my lord, I cannot pay the loan. Kindly waive it. So far as, my lord, the amount they are disputed.
Was the loan taken?
2006. The exact date is 26th of October 2006. Initial amount of 15 lakhs.
26th
October
Acha.
2006. Initial amount of 15 lakhs.
Oh, initial amount was 15 lakhs.
15 lakhs. Excellent, Didi.
I come back to you.
After that, my lord, another 1.5 lakhs.
15 lakhs was taken when?
15 lakhs, my lord, in 26th of October 2006, my lord, the initial amount, my lord, was.
Thereafter,
granted.
1.5 lakhs.
1.5 lakhs, and after that, 1 lakhs. My lord, total 17 lakhs 50,000. This was the total amount, my lord.
No, when was that 1.5 lakhs taken?
But exact date, my lord, is not given, my lord.
Tentative?
My lord, my lord, during the, my lord, construction of the house, because these loans are, my lord, granted by the Housing Federation.
Now construction has been
Construction
made.
is, my lord, long made.
There is no problem in
There is no
cancelling.
problem, my lord.
So how much does it earn to? 17 lakhs something.
17 lakh 50,000. 17 lakh 15,000. That is the total amount, my lord, of loan taken.
The government does not get money. You take 17 lakhs first. We will hear the appeal. Solve the problem.
My lord, the difficulty, my lord.
Every time you will fight the litigation, another 5 years will go.
My lord, kindly, my lord, considers this aspect, my lord. In the meantime, my lord, I have preferred a execution application, my lord, before the DRCS.
We are talking of settlement.
How much have they paid?
Till now?
Yes.
My lord, till now, my lord, total 22 lakhs is pending till
How much
date.
have they paid?
They have paid EMI, my lord, till 2010.
Sir, tell us how much is the amount?
Exact amount.
EMI till 2012.
2010.
2010.
2010, my lord, till 2010, the EMI, monthly EMI, my lord, they have paid.
So what were you doing after that for 10 years?
Well, proceedings were initiated after that, my lord, immediately.
7 lakh 5 baki, interest হচ্ছে 15 lakh 15.
So the principal is 7 lakh 5 from the pleadings, it appears.
From the pleadings,
and the interest you are 15 lakhs.
But kindly consider, my lord, the period of loan, my lord, 2000. My lord,
This is your principal. He will immediately deposit it and interest you will bring it down.
Let me, my lord, take instruction, my
He
lord.
will make installments and she will pay.
How much interest have you charged on the loan?
6%, my lord.
7.5%.
7.5%, my lord. 7.5%. But it's a government organization, it's a standard rate, my lord.
You are right. Government. Sir, tell your clients as regards the.
But I'll take instruction on this, my lord, whether, my lord.
Let the balance be maintained.
My lord.
He cannot go free. He will pay that amount.
I can pay the principal amount in one go, but I'm not able to pay the interest amount.
He will pay installments by.
No. One time go, I can pay the principal amount.
No, principal amount, but the total interest amount cannot be waived.
My lord,
Try to be reasonable.
Actually, the petitioner, who is the person, he is facing some problem, health issues, and he is currently under treatment. That is the difficulty. They are not able to pay the interest amount.
Madam, you take instruction. 7 lakhs odd is the principal amount
Yes, my lord.
that you can pay in one go.
Yes, my lord.
The total interest amount cannot be waived. So the interest amount which has accumulated is 15 lakh something. But you have paid EMI till 2010. What is it?
Yes, yes.
Something you have to pay. Otherwise, we cannot. If you do not pay and if we do not entertain your appeal, he will become more sick.
Yes, yes. Actually, he is.
So convince your client
Okay.
that court has expressed this, that 15 lakhs is the principal. That we will consider.
17 lakh 50,000.
17 lakhs is the interest that we will consider. But you have to pay the amount. Na? Totally you cannot go. No? So when can you take instruction and come?
My lord, yes. Telling the affidavit of service.
ওরে দাও কিছু
My lord, I'll take instruction on this one.
Try and get some sort of a concession.
But I'll take instruction on this. I'll take instruction.
And that amount we will direct him, he will.
My lord, I'll take instruction on this.
Hard Miss Das, learned advocate.
That point of time, my lord, can I make the submission of installment? Not
Yes, we will give you installment. And you will have to argue. Evidence.
Appeal against an ad interim order, affidavits are ready before my lord the learned single judge. And my lord, not only that, after filing the appeal, my learned friends have approached the learned single judge with a CAN application.
My lord, I have a very simple point here, my lord. My lord, there was an interim order operating, my lord, for 2 rounds in the same litigation. I have succeeded every time I've come against a banning order, and my lord, a review, my lord, order passed against, my lord, on the basis of my representation, my lord, I have succeeded. Now, my lord, I'll just indicate to your lordships, my lord, there are two tenders, my lord, which are, my lord, involved. My lord, this is Coal India and its subsidiaries. My lord, they have running contracts. My client, my lord, manufactures and sells explosives. My lord, there are, for mining operations, my lord, these explosives are required by Coal India. My lord, there are two kinds of explosives. One is, my lord, cartridge explosive, and the other is bulk explosive. Now, cartridge explosives, my lord, are decided sometime by June, July, my lord, and it's for every 2 years. Similarly, my lord, for bulk, my lord, the decisions taken, my lord, September, October, and it's, my lord, for 2 years. Now, my lord, I was, my lord, for, my lord, 5 decades, we've been supplying, my lord, Coal India and its subsidiaries. I was, my lord.
The cartridge or the?
My lord, both. I'm one of the largest manufacturers of, my lord, explosives in the country. Now, my lord, I was banned for 2 years on the basis of proceedings initiated by, my lord, an unknown complaint, my lord, to, my lord, the coal minister. That's referred to in the show cause notice. My lord, the rules, my lord, provide that, my lord, I can make a representation to the chairman of Coal India for, my lord, review. My lord, immediately on the banning order being given in 2024, my lord, in July, my lord, I made that representation. My lord, no steps, my lord, were taken on that. I wrote a reminder, my lord, saying, my lord, how I have already suffered, my lord, of non-participation in a tender worth over 300 crores. My lord, that was also not considered. Instead, my lord, they started, my lord, another tender process by a my lord, NIT. My lord, they have it, my lord, the notice inviting tender. Before that, there is what they call a pre-notice inviting tender. So that's when I filed my writ petition challenging the banning order and complaining about my review not being taken up. The learned judge, my lord, said that, my lord, the court would not go into the merits of the banning order, but directed, my lord, the chairman, my lord, of Coal India, my lord, to decide on the review. My lord, that decision, my lord, which was made, if I may call it, my lord, the first review order, and, my lord, the court granted an interim, sorry, my lord, I forgot one aspect, that 20th January 2025 order, court granted an interim order, my lord, that, my lord, my lord, tenders, my lord, I could file, participate, subject to decision, my lord, in the banning, my lord, proceedings. Now, my lord, what happens? My lord, my lord, file, my lord, my representation again, and my earlier representation clubbed together and they're taken up. My lord, the review, my lord, confirms the banning order. My lord, that confirmation itself was, my lord, contrary to orders of court, and, my lord, the terms and conditions of the purchase manual, which, my lord, also, my lord, provides, my lord, for proportionality. My lord, which is to be decided, my lord, on the basis of loss suffered and the graveness, my lord, of, my lord, the, my lord, conduct.
Now the writ petition thereafter.
My lord, then I filed a second writ. My lord, challenging, my lord, this, my lord, banning order, my lord.
You were enjoying the interim order.
Correct. Now, my lord, I succeeded in the second writ. That, my lord, this was contrary, my lord, to, my lord, and, my lord, the rules were interpreted. So, my lord, that review was asked to be reconsidered.
So there's the
third round. Now, my lord, what happens, my lord, the day, my lord, that day, my lord, reject, my lord, my lord, review, same day, my lord, what happens is, my lord, my technical bid, my lord, is rejected.
Which was the day? When?
My lord, that was, my lord, I'll give your lordship, my lord, the date. 2nd of May 2025.
So now, Mr. Shah, what has
No, my lord, it hasn't ended there. Now, my lord, may I tell your lordship? So, my lord, now, my lord, no, my lord, yes, which is why, my lord, it's a very easy argument to make, my lord, that this has happened. Now, my lord, what happens? My lord, while, my lord, technical, my lord, bid is rejected, before, and this is only for cartridge. This is only cartridge which had a pre-NIT that time. So, my lord, what do? I file my lord, third writ, and I point out, my lord, that these are the facts which have happened. The learned judge, my lord, and I want, my lord, a stay on, my lord, the cartridge, my lord, tender. There's no other tender then at that time. Now, my lord, what happens? My lord, what happens then is, my lord, when I move the writ petition, the learned judge says, yes, I must admit it, validity of this has to be decided, this particular order. And, my lord, but says there's no scope. my lord, there was an earlier order, my lord, which says that I should, my lord, be allowed to participate. So I came up before your lordships. Now what has happened, which my learned friend talks about, now, my lord, what has happened is a pre-NIT for the bulk. So, my lord, that is why, my lord, I made an application. Now, my lord, when I wanted that to be taken up also by the learned judge, we mentioned the matter. My lord, the point was, oh, they have a similar issue before the appellate court. So the learned judge said,
So that writ petition has become infructuous.
no. The last writ petition is pending. My lord, the learned judge says validity.
Purpose for which you wanted an interim protection.
Interim protection, that's why I came up. And now, my lord, while the writ is pending, while the appeal is pending, now the bulk, my lord, has happened.
You have challenged both.
Correct. I have to challenge the bulk also.
Appeal from both.
No. The other one, my lord, I've made the application. There's no order. But my lord, the mentioning, my lord, when we mentioned for listing of that application, my lord, kindly hear it tomorrow.
The cartridge tender is over now.
Yes, already tendered.
No. I don't know, my lord. When they have said so in the affidavit. The date I don't know whether when it.
Did they say in the affidavit?
That, my lord, the cartridge tender work order has been issued.
Oh, I see.
And supply commence.
My lord,
Very good.
maybe. Now, my lord, I have made an application for the
Immediate
bulk.
necessity is bulk.
My lord, for bulk, which is pending before the learned judge.
Application.
Yes.
Interim application.
Correct. And my lord, what they mention when we mention it, my lord, for my lord being listed.
So what do you want from us, Mr. Mukherjee?
My lord, I want, my lord, first.
Your application to be heard.
Correct. My lord, I want, my lord, that either your appeal can't stand in the way of that application being heard. I want my application to be heard.
So we will make that observation.
I have no difficulty at all.
No, but they objected, my lord, when I.
Mr. Mukherjee, so if you make a one-line observation that pendency of this appeal will not.
Yes, my lord, I'll be at liberty to proceed for the time being. That's fine.
This appeal is concerned, appeal is against an ad interim order. My lord, the ad interim order also directed exchange of affidavits. That is complete.
Yes, they were out of time. My lord, I did my affidavit in reply in 3 days so that, my lord, the matter could be mentioned.
That was in the cartridge.
No, my lord, it covers.
Cartridge bulk, it is one.
No.
Banning order covers everything.
Banning order covers everything, right? So it's both. So, my lord, my interim order, my lord, was urgent, my lord, because of cartridge, which was the tender in, my lord, question, my lord, at that time.
While this was going on.
Now the bulk has come. The banning order operates in respect of both.
No, as regards the cartridge tender, that Mr. Shah says what could.
My lord, your lordship will decide. My lord, that can be decided in the appeal. Yes.
We will, in this appeal, we will only say that we will ask you to exchange pleadings and we will say pendency will not
prevent the, my lord, application to be taken up. I'm happy with that. And my lord, in the appeal, my lord, this was, my lord, only the writ petition. My lord, nothing else to file. My lord,
petition to hearing Korea now.
writ to George Bollo nebe na bole. I have to mention before. No. Interim. My lord, I'll tell your lordships, my lord. My lord, we also said, my lord, if the main matter could be taken up. The learned judge said determination says there are so many other benches, I don't have time. So, my lord, at least my interim application should be taken up because we'll. My lord, I appreciate, my lord, the difficulty the learned judges.
There is no difficulty. We have no difficulty.
My lord, kindly hear the appeal and give us this liberty, my lord, to move our interim application. It should not stand in the way.
Yes, we'll just mention that pendency of the appeal.
Yes, I'm happy with that. I'm happy.
No, কিন্তু ওরা তো একটা
Active.
তাদের petition entry order না হলে তখন তো আবার একটা এইটাকে বাঁচিয়ে রেখে আর কি করি dispose of করি
এটা তো ভোট কার্ড ব্যালেন্স থেকে
ও আচ্ছা
এটা তো থার্ড রিটে এই অর্ডারটা হয়েছে বা এই অ্যাপ্লিকেশনটা পেন্ডিং আছে
না এটা কি ব্যাংক কনসিডারেশনটা আমরা যদি হাতে রাখি ইন্টারিম অর্ডারটা in order did you pray for that application with
My lord, my lord,
The bulk should not proceed without.
Not bulk, my lord, what I,
The banning order.
There should be an injunction.
yes, banning order, and the only tender, my lord, which was there at that point of time was cartridge. Now they've come with bulk, my lord. So, my lord, we made an application that bulk is happening. My lord, there that
So you
technical,
want participation
correct,
subject to the result
correct,
of
correct.
the-
No, my lord.
My lord, my lord, may I show your lordship? My lord, the interim order which the learned judge has passed, had passed earlier, my lord. Kindly have a look, my lord, at,
Hey, file to দাও।
my lord, where is it marked here? My lord, page 792, my lord, kindly have a look.
Sorry, Mr. Mogachi, where do we find the order?
Yes, I'm giving that page, my lord.
791.
My lord, page, my lord, it starts, my lord, if your lordship kindly takes. My lord, page, my lord, 792, volume 4.
Yes, got it.
My lord, kindly come to page 794. My lord, 794. My lord, paragraph 11.
If any NIT is published in the
In the meantime, if any NIT is published, then the petitioners may be permitted to submit their bid, and the fate of the bid submitted will be subject to fate of the representation filed by the petitioner seeking review. The only modification here will be till, my lord, the writ, because this is decided in September. I'm willing to, my lord, have the writ petition heard also before, but the learned judge pointed out, my lord, that because of the heavy, my lord, load, my lord, it would be better if we mention final hearing elsewhere. But she was willing to consider, my lord, this application of ours for interim relief. But, my lord, the other side said there's an appeal pending where they've made a omnibus prayer for.
May I show you, lordship, my lord, the two orders
and the
in order
fate
of
of
time.
the bid submitted will be subject to the fate of the presentation. No, the order which is impugned in the
Impugned in this, my lord, kindly take the memorandum of appeal. My lord, kindly see, my lord, 13th May 2025.
There was no scope for an interim order.
That's what the learned judge held. My lord, I asked for an interim order, my lord, on, my lord, the cartridge, which was because the day, my lord, this impugned order was passed, the same day, my lord, they opened the technical and said you are not.
No, where is that interim order application? Is it
My lord,
in
the writ
paper mode?
petition, my lord, kindly have a look at
File this can one.
can 1, my lord.
That is filed after 13th of May.
Yes, yes.
Where is that?
I have.
I can hand up a copy to you.
My lord, I have copies.
What was the prayer?
Yes.
My lord, I've made it less bulky without the annexures, my lord. Kindly have a look, my lord. My lord, kindly have a look at page 29, my lord.
Direction to participate also in the order in terms of.
My lord, this is an event after that order.
A number of people. So we are asking you to prepare paper books and file.
Very well.
And we will say that pendency of the appeal will not
I'm grateful.
prevent the learned signature.
I'm grateful. That's all I can ask for, my lord.
You know, sir.
The present appeal is from an order of the
As they have withdrawn the writ petition.
Both are appellants, both are
appellants, there is clause that
But he's the first appellant, na? He's item number 1.
Item number 3, my lord.
1 and 2 is
Was.
they are mine, my lord.
My appeal was filed earlier. 1,
My-
2 and 3 are all together.
Yes, together, my lord. 1 against my lord, the impugned order, 1 against my lord, rejection of my application for recalling the order. So 2 appeals were filed. My lord, this has become infructuous, but one thing, my lord, one sentence has to be added. My lord, kindly have a look at page 3 of the interim order. There is, my lord, earlier a status quo order was passed. Lordship sees page 3, second paragraph. So, well, the status quo order has to be vacated and the port authority may have the liberty to proceed in accordance with law. That's what I wanted, man. I'm praying for that before the Lordship. Well, there is a status quo. That should be machineries, man. That should be machineries. That should be machineries.
No, but you're both withdrawing both. All
The
three
writ petition has been withdrawn, my lord.
Withdrawn, so I
My lord,
cannot.
appeal has become infructuous.
Oh, writ petition has been
Yes, my lord, it has been withdrawn. This is the order, my lord. By order of 11th June, my lord, it has been withdrawn.
Withdrawn. So,
रीट पिटिशन ही तो नहीं
Yes,
और क्या
well, there is a status quo order in this appeal. So that's what I'm saying.
we will dismiss these appeals as infructuous because the writ petition has been withdrawn.
Man,
In connection with the orders passed in that writ, you have come, na?
but as an authority, because a proceeding is going on
Okay,
before
sir.
the estate officer, there has to be, my lord, a recording. The status quo order is also vacated, and my lord, he can proceed under section 6. Well, that's what he's going.
We are saying appeal has become infructuous. There is no existence of any order whatsoever. Writ petition has been withdrawn.
Just to, well,
Oh,
have any confusion, that's what I'm
All
saying.
interim orders are vacated. All interim orders are vacated.
On the interim order vacated, liberty to proceed in accordance with law. That's what I am.
Order pass হয়েছে দুটোতে accept. So we pass one order in first 2 appeals, taking together, and the separate order in your.
My lord, regarding serial number 3, my lord, I have the instructions letter.
Let my lord dictate the first one.
1 and 2.
এই কোশ্চেনটা দিয়ে দিও।
Parties are represented. Stop. We are informed that the writ petition being WP
Yes. Yes, Mr. Ojumdar.
No, judgments were cited at the bar in support of the proposition that at a belated stage, I cannot incorporate pleadings. This is probably where my learned friends are not appreciating the supplementary affidavits for their true scope and purport. Please come to page 28B for instance once.
28?
28 capital B of the stay application.
Yes.
Paragraph 2 at 28B. That this deponent most humbly crave leave to file this instant supplementary affidavit so as to incorporate two documents. I am not seeking to alter or not incorporate any pleading. I seek to bring two evidence in support of the pleading which is already there at page 21 of the writ petition. And I just read that corresponding pleading in the writ petition. The construction as proposed in the said brochure has several implications for the residents of Obhidepta Phase 1, as it appears that the company obtained sanction from KMC through a number of illegal acts, illegal activities, manipulation, misrepresentation, distortion of facts, and figures in particular for getting additional FAR by utilizing the entire.
Sorry, Mr. Ojumdar, we missed the page. Page
21 of the writ petition, the bulky one.
একটু বড়টা দাও।
Twenty-one. But obviously, I had to disclose the relevancy of those documents in the affidavit. That pleading is only in support of explaining the relevancy. Please come to the first subparagraph of that page. The construction as proposed in the said brochure has several implications for the residents of Obhidepta Phase 1, as it appears that the company obtained sanction from KMC through a number of illegal acts, activities, manipulation, misrepresentation, distortion of facts and figures, in particular for getting additional FAR by utilizing the entire 12.27 acres instead of the actual 3.23 acres set aside to be utilized for future development inter alia phase 2 together with the commercial complex cum shopping arcade, as it was categorically made clear by the respondents through its registered cell deed that the residents of phase 1 have exclusive right on to 9.04 acres out of 12.27 acres of land. Therefore, the exclusive right to be available unutilized FAR at Obhidepta Phase 1 can never be transferred for future development. Please see note vis-a-vis this at page 33 of the stay application once again. And this is the application for obtaining the sanction plan, beginning at page 32 of the stay application.
Yes, which paragraph?
Page 33 of the stay application. It's a document. It's the document.
Yes.
It starts at 32. Is the application for sanction of plan. Please come to 33. 6.1.
Yes.
Please come to 33, paragraph 6.1. I mean the column 6.1. Area of land. Entry A thereunder is as per deed square meters 51,273.24 square meter, which comes to 12.6 acres. And with the number of stories mentioned in paragraph, I mean entry number 7.
What prevented you from disclosing that? The writ petitioners? At that time it was.
Have not. This was the moot question in consideration before the KMC.
Mr. Mitro's argument is that it is vis-a-vis an amendment application to which you are replying. But he also placed this supplementary was filed after completion of everything, and that too by the added petitioners, not by you, Mr. Oliver. Then doesn't it becomes, yes, what is your reply to that?
Not belated stage, and not why the original petitioners have not produced, I am producing. Not, this is a document which the KMC authorities themselves ought to have produced. It's a case of misrepresentation, a document lying with the respondents number 7 and 8 and KMC authorities.
That situation was there when the writ petition was filed.
Right. I was added at a later stage. I did not get myself added at the first stage. Not the there was an order.
You could have brought these documents on record prior to the original writ petitioner commencing his arguments.
Yes.
Because by that time pleadings had been completed. You knew this was not on record.
Now, for the purpose of final adjudication of fair conclusion of a judgment to be delivered, the court could have asked this document to be produced at any stage. Today, if not, please see, I am running a case of misrepresentation against the authorities. KMC has decided this. The question is of FAR. All that the court was required to look into is the relevancy of the document. This is KMC's document, which I may submit that they have willfully not disclosed before the Honorable Court.
So, is there any line in the writ petition that documents have been suppressed by KMC in your original writ petition?
Please come to on page 30, paragraph 34. Paragraph 34 of the writ petition.
Page 34.
Page 30, paragraph 34.
Yes, sir.
I'm sorry.
So, at the time of hearing before KMC, that was on the basis of how that hearing is conducted. In a prescribed form, you have to file an application.
I made a representation complaint.
On that.
Before the court, we had to approach because they were sitting tight. The court sent it on remand. Then we asked for these documents to be produced. The order was passed. And that's recorded at page 271 of the writ application. I just read that particular paragraph from the order at page 271. Order script.
This is
I'm
what
sorry,
is this
your
271?
representation. Page
Your
271.
representation.
What do you have to do? You've placed this, Mr. Wali.
Page 271.
You've already placed it.
Not paragraph 31 says that the relevant documents were asked for but not provided. Now, lords, we will kindly have a look at a very interesting feature at page 68. It begins, the affidavit begins at page 63.
Mr. Imdad, when were you added as a party to the proceedings? Can you
Date
give
of
us
the
a
order.
date?
Just give the date of the order.
Not your representation, but the original petitioner.
Adequacy. VT order.
এই মিঠুন, এই যে পার্টি অ্যাড হলে তো তোমরা অরিজিনাল সাইডে ডিপার্টমেন্টে করে দেয় না? তাহলে ওইটা স্ট্যাম্প মেরে তো দেয় কবে অ্যাডেড হলো। Page
63
of the
stay application. But this is an affidavit used on behalf of the respondent number 8.
Week 8. So, সেখানে প্রপার্টিটা তো মানে বাইপাসে যেটা page 63. Yes,
Please come to note. This is an affidavit in opposition used in connection with the proceeding. I am the company secretary and compliance officer of Bengal Peerless Housing Development Company Limited, the respondent number 8. Copy of the instant writ petition has been served upon the respondent number 7, the statutory body, West Bengal Housing Board. So respondent number 8 is replying in favor, also on behalf of respondent number 7, a statutory body. Now please come to page 67.
No, a copy of the instant writ petition was served upon respondent number 7. So you are meaning to say that 7 gave him the writ petition?
Respondent number 8 is answering.
8 has a share in 7, I think. Yeah, that's right.
But it is a statutory body. It's a body created by statute.
No, but it's
now please come to page 67.
It's permissible in law.
Right. Now please come to page 67.
Board, nominee on the board is also there.
Right. Right.
Page 67.
Yes.
Paragraph 11.
Paragraph 10. Paragraph 11. I say that on 8 July 2009, West Bengal Housing Board, respondent number 7 executed a registered agreement by which the respondent number 8 was appointed as a developer and agent of the respondent number 7 and has been authorized to develop the said land for implementation of a housing complex. Thereupon the LIG, MIG and HIG people with all other facilities and amenities therein and to sell and transfer the said flats I crave leave to refer to the registered agreement at the time of hearing if necessary. So this was a document which they ought to have produced.
This is what one of the documents.
One of the documents. One is the application for sanction, one is this development agreement. One was a screenshot, the other was a chart. Not a chart for the time being, I disregard. Screenshot would show the FAR as disclosed by them before the HIRA. One agreement they themselves wanted to produce. And the application for sanction is a document lying in the records of KMC, which in certiorari jurisdiction in any event, the court could have looked into. So what the question, I'm sorry.
One was the registered agreement, other was the application, and the other one was the.
Third was that screenshot from that
Yes.
document uploaded in HIRA.
Yes.
And fourth was a chart prepared by us, not which in any event not is something not which we can rely even at the time of argument. Your lordships quite often ask us, please prepare a chart in support of your contention, a comparative table, something like that. I'm not paragraph 12. I say that as per the notification under section 29 of the 9th August 2007 issued by the government of West Bengal, neither the respondent number 7 nor the respondent number 8 are allowed to divide or segregate the said 12.67 acres of land for construction of a housing complex thereon. In view of not these pleadings or not these averments being on record, was this application seeking permission for this application for sanction of plan not to be considered a necessary document for the purpose of final judgment to be delivered? Suppose not this matter comes up.
That Mr. Banerjee said that at the time of addition, there was no. Have you got that?
Yes, yes. 4 December 2018.
Please give us a copy. Petition. Leave the need to produce additional documents.
Didi.
Such certain present application is allowed. There will be an order in terms of prayer repeat. What is it? এটা তো 4 ডিসেম্বর
Now, please take note the purpose of the second supplementary affidavit also at page 98. Paragraph 2 also records the purpose for which the supplementary affidavit was filed. I have affirmed this affidavit on 1st of December 2022 in order to put on record certain material facts and documents.
What are you reading, Mr. Owner?
Page 98 of the stay application. 98. 98. I have already affirmed an affidavit on so and so in order to put on record certain material facts and documents which in my respectful submission are relevant for effective adjudication of the writ petition. Then note there is a tabulated there is a table in Annexure C and so unit the screenshots in paragraph 5 environment clearance if I are exceeded, not these facts are already there in the writ petition. These facts might not have been required to be put in the affidavit. But not these two documents are essentially sought to be introduced. One was a chart, the other was that screenshot.
Sure. Good. That's all, Mr. Ojeda?
Now, the judgments which have been cited. No, that res judicata, point of res judicata. That prayer B was, it applies at every stage of the proceeding. But I get a document, not subsequently I am debarred from producing it before the court for all time to come.
No, the point of res judicata, if I've understood correctly, is this: that when you were added, you had a prayer in your application saying, I want to file pleadings, which by implication, since that was not allowed, it's construed under
Section 11.
Section 11, I think 4th or 5th proviso.
I am not pressing for any pleadings to be taken into consideration. I am pressing for these documents
disclosure of some documents which they have themselves said in their affidavit, I want to produce at the time of hearing.
And what this would enable the court to pronounce a final judgment. But please visualize the situation. If the court wants this document for final adjudication, I could have produced this by way of an Order 41 Rule 27 scenario. Today, I am debarred from producing this. The sole question which ought to be addressed was whether these documents are necessary for the purpose of adjudication.
Relevancy of the documents.
That's the relevance. And this pleading should be restricted to the scope of relevancy being explained in support of this evidence being adduced. And not in read jurisdiction, your lords have repeatedly laid down the law that the means should not defeat the ends.
How long will a court wait? If you take 5 years time to come and say at the fag end of hearing, how long you expect the court will give you?
Not even
then these principles goes, na? Amendment also, Supreme Court said that after this particular stage you cannot allow.
Not after all, it's the ends of justice. Not 90 days was incorporated for the purpose of shortening.
Ends of justice also for them. Also for them. It is not only...
Justice is not final adjudication. But whether in a case of misrepresentation being the only available ground on which
the original petitioners also did not proceed on this because they ought to have been more vigilant.
I have shown to your lordship not this page 21 of the writ petition.
Yes, page 21, that misrepresentation allegation.
That's the ground, the FAR, that's the situation, which can be ascertained from these two facts. Section 397 only permits a sanction plan to be attacked on the ground of misrepresentation. This is the square case run in the writ petition that there has been a case of misrepresentation through a false declaration resulting in additional FAR. These two documents, one of them, the respondents themselves want to rely upon.
Which judgment you want to distinguish?
May I start from 2014 Calcutta? This was cited by Mr. Abhrojit Mitra as the first judgment. This was a case of.
So you will criticize the judgment or the judge?
No. Not I may be hauled up in contempt, not if I say yes to both.
মিত্র সাহেব দিয়েছিলেন পরেটা। অরিন্দমের গুলো আলাদা ইয়ে করা আছে।
SCC online Calcutta.
আমার কষ্ট হবে।
Now, this was a case of challenging a selection process, an appointment. Please come to the second page, note the paragraph beginning with the words, it is explicit from the averments. It is explicit from the averments made in the reply that the petitioner had not challenged the procedure adopted by the school authorities towards filling up the said post. No ground had been taken in the writ challenging the applicability of the recruitment rules. By a supplementary affidavit, the petitioner had sought to introduce new grounds of challenge. It is well settled that by way of supplementary affidavit, a new case cannot be made out.
Yes.
Then note that APOT 78 of 2025, the unreported judgment, Joy Surana versus the Calcutta Swimming Club.
ওটা কোথায় গো? এটা মোটা বাঁধা ছিল। হ্যাঁ। Yes.
Please come to paragraph 28 at page 27. The learned single judge has taken a view and has exercised his discretion in a particular manner. We cannot say that the order is perverse. In an intra-court appeal, even if the appellate court has a view different from that of the learned single judge, unless the order appealed against is clearly wrong or perverse or shocks the conscience of the appeal court, no interference with the order is warranted so long as the order reflects a plausible view. But of course not, this arose out of a suit where an injunction order was not granted. Passing of an injunction is always a discretionary relief.
Yes.
So not a refusal to pass an ad interim relief to a club member in a civil suit while exercising discretionary relief cannot be equated with a case of non-production of a relevant document. Paragraph 1 is the order from which the appeal arose.
Then
AIR 1981, Supreme Court 588.
Yes. এরপরেরটা খুঁজো 183 CHN 105. Yes.
That paragraph 4 of that report. The case of the petitioners in the writ petitions is that the government of India was not empowered to fill up the reserved vacancies by recourse to a departmental competitive examination for candidates from the SCs and STs, and that instead the government should have reserved the vacancies and made them available to candidates falling under the general category. Had that been done, the petitioners say, they would have been considered for promotion, and having regard to their position in the select list, they allege that they stood a probable chance of being promoted to grade 1. The petitioners pray that the amendment of Rule 12, Central Secretariat Service Rules and the framing of regulations pursuant to the amendment should be declared ultra vires. Alternatively, the amendment of the rules and the framing of the related regulations be regarded as prospective only and not affecting the 27 reserved vacancies pertaining to the year 1977. It is also prayed that the Union of India should be directed to take immediate steps for de-reserving the 27 vacancies for the year 1977, and upon such de-reservation, the petitioners be considered for filling those 27 vacancies. So, this was the case which was run by the petitioners in that case. The question of possessing qualification apropos the rules which stood amended came to be considered by the Honorable Supreme Court in that case. An Article 32 petition challenging the rules holding a departmental competitive examination.
Yes. In 18.3.
Then, Lord, it's an unreported judgment in case of Bharat Coking Coal Limited versus Free Enterprises.
That is 18.3 CH.
Yes, 18.3 CHN.
Yes.
But in that case, BCCL had forfeited a deposit in a sale transaction from one of its buyers. And the facts are available at paragraph 1. Now please come to paragraph 17. Please come to paragraph 16 first. Normally, a writ court would be loath to interfere in contractual disputes is settled law. It is, however, clear on perusal of the aforesaid extracts from the decision in Joshi Technologies that in exceptional cases, a writ court may be justified in entertaining a writ petition, even though alternative remedy by way of a dispute resolution mechanism embodied in the agreement between the parties is either available or a civil suit could be instituted for damages for breach of contract. Then please see the last sentence of that paragraph. What we now have before us is a reasoned decision given by the learned judge on the merits of the dispute. The point that immediately strikes us is to what extent interest of justice would be subserved by relegating the parties to arbitration without considering whether the learned judge was justified in returning the findings he did. If indeed we are adhering with such findings, yet we choose to uphold the technical objection of BCCL that a forum before the arbitral tribunal were available, the entire exercise undertaken by the learned judge as well as by us to hear the parties on the merits of the dispute would be exercised in futility. We shall therefore focus on the preliminary objections to the maintainability of the writ petition raised by Mr. Jose, and if it is found that the exercise undertaken by the learned judge did not require examination of any disputed question of fact, that some degree of public law element is present, that the impugned decision is the result of proper appreciation of the materials on record, and that proper application of mind by the learned judge is apparent, we may not hesitate to reject the objections, although it could be quite possible for the writ petitioners to obtain a similar decision before an arbitrator. So, on merit, the Honorable Single Judge has decided the court was examining as to whether to uphold the preliminary objection as regards availability of a different remedy. In that context, the next sentence note runs. It cannot be gainsaid that the courts exist to administer substantial justice, and if over a long-run process of litigation before the High Court a party is successful in proving its point, it would require the aggrieved party to set up a cast iron case to have the decision upturned and to have the parties successful before the writ court to be relegated to the alternate forum. After all, we are exercising the jurisdiction conferred by clause 15 of the letters patent, and it is right that in an intra-court appeal, the appellate court does not interfere unless, of course, the decision challenged before it meets the test of perversity or when the decision is clearly wrong and not when it is not right. Now, that's probably 81 Supreme Court Justice Krishna's paragraph 73 last sentence. Gujarat Steel Tubes case. Now, the other judgments not probably on clause 15 of the letters patent. whether this appeal is maintainable. But the other judgments are all on these two proposition as to whether an amendment, there can be a pleading amended at a later stage. And all these judgments had been cited at the bar, which are more or less on similar lines. There can be no evidence without a pleading. Then what cannot be done directly cannot be done indirectly. This is not a judgment, therefore this is not appealable. 2023 1 SCC 634 sham sales judgment. Please have a look at that judgment.
Page of
2023 1 SCC 634.
There are three kinds of judgments, Mr. Banerjee told us. Stamp steel, right?
Hello?
Three kinds of judgments.
Not one was in an intra-court appeal, the appeal court is not to interfere if a এক SCC
23 volume 1 SCC page 634 না বই দেয়নি কপি দিয়েছি you tell us what is your argument.
And may I read from paragraph 4 paragraphs, paragraph 18 first. That it in extenso quotes Babulal Khimji. Then paragraph 18. It could thus be seen that though this court in Shah Babulal Khimji has held that the term judgment used in letters patent could not be given a narrower meaning as is given to the term quote-unquote judgment used in CPC, and that it should receive a much wider and more liberal interpretation. However, at the same time, each and every order passed by the trial judge could not be constituted to be a judgment inasmuch as there will be no end to the number of orders which would be appealable under the letters patent. It has been held that the word judgment has undoubtedly a concept of finality in a broader and not in narrower sense. It has been held that where an order vitally affects a valuable right of the defendants, it will undoubtedly be treated as a judgment within the meaning of letters patent so as to be appealable to a larger bench. But here it's a question of the evidence not being allowed to be produced.
This was paragraph?
Paragraph 18. Then paragraph 19. It has been held in Khimji that most of the interlocutory orders which contain the quality of finality are clearly specified in clauses A to W of Order 43 Rule 1 of CPC and would be judgments within the meaning of the letters patent and therefore appealable. However, there may be interlocutory orders which are not covered by Order 43 Rule 1, but which also possess the characteristics and trappings of finality, inasmuch as such orders may adversely affect a valuable right of the party or decide an important aspect of the trial in an ancillary proceeding. It has further been held that, however, for such an order to be a judgment, an adverse effect of the party concerned must be direct and immediate rather than indirect or remote. Various illustrations of interlocutory orders have been given, which could be held to be appealable. This court in Khimji held that though any discretion exercised or routine orders passed by the trial judge in course of the suit may cause some inconvenience or to some extent prejudice to one party or the other, they cannot be treated as a judgment unless they contain the traits and trappings of finality.
Page. Oh. Yes.
Now I'm not coming over to paragraph 22.
Yes.
It could thus be seen that both the judgments as well as Khimji have a common thread that as to whether an order impugned would be a judgment within the scope of clause 15 of the letters patent, would depend on the facts and circumstances of each case. However, for such an order to be construed as a judgment, it must have the traits and trappings of finality. To come within the ambit of judgment, such an order must affect vital and valuable rights of the parties, which works serious injustice to the party concerned. Each and every order passed by the court during the course of the trial, though may cause some inconvenience to one of the parties, or to some extent some prejudice to one of the parties, cannot be treated as a judgment. If such is permitted, the floodgate of appeals would be open against the order of the single judge. In the light of this observation, we will have to consider as to whether the order passed on 2019 could be construed as a judgment within the meaning of clause 15 of the letters of patent. Then please come to paragraph 26. It is thus clear that there was no adjudication with regard to the rights of the respondent plaintiff to get an ad interim injunction during the pendency of the suit. The question of granting an injunction is always a scope of discretion. That's statutorily laid down. Though by postponement of the issue with regard to grant of ad interim injunction, the order might have caused some inconvenience and maybe to some extent prejudice to the respondent plaintiff, the same could not be treated as a judgment, inasmuch as there was no conclusive finding as to whether the respondent plaintiff was entitled for grant of ad interim injunction or not. So the court had postponed the date of consideration of granting the ad interim injunction on a later date from which the appeal was taken out.
Yes.
Now, paragraph 31. It is difficult to appreciate the anxiety on the part of the division bench of the High Court to itself dispose of the interlocutory application instead of relegating it to the court below for its disposal. When the division bench of the High Court itself took 8 to 9 months to decide the appeal, it is difficult to understand as to what the learned judges of the division bench of the High Court meant by quote-unquote unnecessary prolongation of the litigation and utter wastage of time. So the court goes on to observe on the facts of that case. So whether a party is prejudiced or whether it is necessary for the purpose of adjudication of the case or not, that will depend upon the facts and circumstances of each case. And in my most respectful submission, the principle of Order 6, Rule 17 ought not to have been applied. What ought to have been considered was the principle of Order 41, Rule 27. More so when the question is one of misrepresentation.
All right. Thank you.
These are my submissions.
But one judgment just rendered 15-20 days ago. Justice Pardiwala, I can cite here and give it to your lordship, subject my lord's. But it's on that interlocutory orders operate as res judicata, where an order 1 Rule 10 application was rejected by the court on the ground of interlocutory res judicata upheld by the court. In that even it was earlier stage, they were not substituted. Order 1 Rule 10 would stand in the way of their being added by interlocutory res judicata. But I've had that judgment. It's 2025 INSC 764. May I formally cite that? Your lordship's pardon.
We have concluded, Mr. Vaz.
And not to what extent your lordships will apply these suit proceedings in the writ jurisdiction, I leave it to lordship's discretion. These are all orders arising from suits, the cited judgments.
See, applies in writ proceedings.
To the extent is possible.
The learned
That's Rule
advocates
53.
appearing for the respective office